To order. A quorum is present. The committee meets today pursuant to notice to consider 5 bills. The chair announces that requests for recorded votes may be postponed pursuant to Clause 2 of Rule 11 of the Rules of the House of Representatives and Committee Rule 14B. Without objection, the chair may recess the committee at any point. Today, the committee will be marking up 5 important pieces of legislation. H.R. 1319, the Modern Worker Empowerment Act, supports independent contractors by clearly defining the line between employee and independent contractor under the Fair Labor Standards Act and the National Labor Relations Act. As expert witnesses have told the Subcommittee on Workforce Protections, many businesses have experienced administrative whiplash from regulatory changes affecting independent workers. The Modern Worker Empowerment Act will provide certainty for many businesses and independent contractors by using a similar framework that the Trump Department of Labor finalized in 2021. I'd like to thank the American Trucking Associations for their strong support and acknowledge the independent workers who came to join us here today. We'll also consider H.R. 1320, the Modern Worker Security Act. This legislation will provide a safe harbor for businesses offering certain benefits to independent contractors, which are usually reserved for W-2 employees. The government should avoid creating fear and uncertainty among independent contractors about reclassification as employees, especially because the vast majority of these workers have made it clear they do not wish to become employees. This bill will remove illogical disincentives to providing independent workers with benefits. I'd like to thank Congressman Kiley for leading both these bills and for his expertise and passion on this issue. The next bill, authored by Congressman Comer, is H.R. 4366, the Save Local Businesses Act, which protects the opportunity for all workers to pursue the American dream. Specifically, this legislation will set one common-sense joint employer test so that job creators will have clarity about the law, of what the law is, and certainty for the future. For too long, we have allowed the National Labor Relations Board and DOL to determine their respective joint employer tests, resulting in tests that change with every presidential administration. The Biden-Harris administration's joint employer standard created immense uncertainty and imposed massive costs on thousands of businesses nationwide. The Save Local Business Act will reverse the damage done by the Biden-Harris administration and allow Americans, especially Americans in the franchise industry, to start and grow their businesses without fear or uncertainty. We'll next consider H.R. 4312, the Student Compensation and Opportunity Through Rights and Endorsement Act, led by Representative Gus Bilirakis, House Republican Conference Chairwoman Lisa McClain, as well, whose work on this issue is much appreciated, myself and many others. The SCORE Act, a bipartisan bill, brings much-needed stability to college athletics. Since the NCAA lifted name, image, and likeness and transfer rules in 2021, college athletics have been in a period of chaos and as constant litigation and efforts to classify student athletes as employees jeopardize thousands of academic and athletic opportunities. H.R. 4312 restores order by establishing a national framework for athlete compensation, clarifying that student athletes are not employees and granting athletic associations authority to enforce consistent rules. Additionally, the SCORE Act protects student athletes' ability to earn NIL compensation and ensures universities provide academic support, degree completion programs, financial literacy, and preparation for life after sports. H.R. 4312 upholds the tradition of college sports by delivering a sustainable framework and protects broad-based academic and athletic opportunities for student athletes. Finally, we'll consider H.R. 4307, the Enhancing Detection of Human Trafficking Act. This bipartisan bill, authored by myself and Congresswoman McBath, will help DOL fight human trafficking and protect vulnerable adults and children. Specifically, this legislation directs the Secretary of Labor to educate DOL enforcement personnel on trafficking, ensures DOL personnel have the tools they need to detect cases of forced labor or sexual exploitation as they investigate employment law violations, establishes a clear framework for DOL employees to assist law enforcement in prosecution and prevention efforts, and requires DOL to provide an annual report to Congress on its efforts to combat human trafficking, which will help guide this committee's future oversight efforts. With that, I yield to the ranking member for an opening statement.
Thank you, Mr. Chairman. Mr. Chairman, today we'll consider 5 bills, 4 of which I'm concerned conflict with the priorities of American workers. Now, after passing the one big ugly law which sacrifices health coverage for over 10 million Americans to pay for tax cuts for the ultra-wealthy, committee Republicans are now seeking to advance a number of bills which will make it harder for Americans to make ends meet and care for themselves and their families. The first 2 bills we'll consider, H.R. 1319 and 1320, will create more loopholes for employers to skirt their responsibility to provide fair play, safe working conditions, and employee benefits. The H.R. 1319, the so-called Modern Worker Empowerment Act, amends the Fair Labor Standards Act and the National Labor Relations Act to establish a single and far too narrow test to determine whether an individual is an independent contractor or an employee. By narrowing the scope of the FLSA and the NLRA, this bill makes it more difficult for workers who have been misclassified as independent contractors to receive overtime pay, fair wages, and other basic rights under the law. I cannot overstate the harm this bill will inflict on workers and communities alike. By codifying the pervasive trend of employers to misclassify their employees as independent contractor, this bill strips workers of their basic wage and hour protections and leaves law-abiding businesses at a competitive disadvantage. Independent contractors do not get the same protection and benefits as employees, such as minimum wage, overtime, unemployment compensation, workers' comp, access to employee health care and pensions, OSHA protection, and the right to organize. And also, this bill would rob state and local governments of revenue at a time when states must deal with devastating health and food assistance cuts due to the president's one big ugly law. Next, H.R. 1320, the so-called Modern Worker Security Act, fights a problem that doesn't even exist. It purports to allow businesses to offer some compensation other than cash to their independent contractors without transforming their business relationship into an employment arrangement under federal law. The problem with that framing is that there is no such problem. There's no law that prohibits companies from offering so-called portable benefits to independent contractors. There's no reason to believe that these benefits would establish an employee relationship. Meanwhile, this bill actually does nothing to promote the offering of non-cash benefits to contractors. The National Employment Law Project put it best when it said, and I quote, "What this bill does is legitimize a corporate-driven model where savings accounts with meager contributions from corporations are touted as portable benefits. Congress must reject these fake portable benefit proposals and instead bolster our existing insurance-based portable benefit system. Instead of rolling back labor protections and legitimizing a system where app-based workers must settle for paltry savings accounts instead of actual benefits," unquote. Next, we will consider H.R. 4366, the Save Local Businesses Act, which does just the opposite of what its name suggests. By rewriting the rules on who counts as a joint employer, this bill strips workers of protections they've relied on for decades and leaves small businesses responsible for actions taken by a completely different company. If more than one company controls your job, both should be held accountable when under the joint employer laws. This bill lets the real decision makers off the hook and makes it harder for workers to fight back when they are underpaid, mistreated, or ignored at the bargaining table, and even creates a situation where technically no one could be the employer. Employees may be, for example, able to prove that they were not paid overtime, but none of the employers, not the temp agency nor the business where they actually work, qualifies as the responsible employer. So nobody's on the hook for the fact that the employees were not paid overtime because nobody's an employer. It also continues a troubling trend in a Republican policy of late, making child labor violations easier. Congress intentionally used a broad definition of employment in the Fair Labor Standards Act because it was borrowing language from early state child labor laws. State lawmakers frequently found that businesses would splinter themselves through contracting and subcontracting to benefit from child labor without penalty. A factory owner might lease the factory to an operator who in turn would retain an independent contractor to provide workers. But state courts would hold the owners accountable in such schemes by applying the same broad language the drafters of the FLSA used to define employment. This bill, however, would narrow that definition, turning the clock back to a time when children did not benefit from the broadest possible protection of the law. Next, we'll consider H.R. 4312, the SCORE Act, which seeks to regulate college athletes in the name, image, and likeness marketplace. While we can all agree that Congress needs to step in to protect students from abuse and exploitation, this legislation misses the mark. Instead of holding the revenue-rich NCAA and its Power Four conferences accountable, the SCORE Act provides a series of blank checks and bailouts that will not uplift or protect college athletes. This bill imposes obligations without oversight, fails to include concrete protections, and outright bans college athletes from ever having labor or employment protections. This extreme employment ban will not only open the door for further exploitation of college athletes and protect athletic departments' bottom lines more than the students they serve, it is a broad stripping of athletes' rights, and that should not be the solution. It also, whatever rights the athletes have under the bill, there's no apparent way for them to enforce those rights. However, there is another solution. If institutions don't want college athletes to be employees, they shouldn't treat them like employees. Lastly, we'll consider H.R. 4304, the Enhancing Detection of Human Trafficking Act. This bipartisan bill, led by you, Mr. Chairman, and Representative from Georgia, Ms. McBath, ensures that the Department of Labor continues training staff to spot and report human trafficking. Wage and hour division inspectors, for example, have long been trained to identify red flags of human trafficking, including confiscation of identification, withholding of documents or pay, restriction of movement or communication of employees, and threats. No one should be forced to work under threats, abuse, or coercion, and this proposal will ensure that DOL continues this vital work. I support the proposal and encourage my colleagues to do so as well. However, it is worth noting that this proposal does nothing to protect federal investments in fighting worker exploitation. Given that the administration is currently seeking to cut staff and resources at the very agencies tasked at stopping human trafficking, and has repeatedly made immigration communities less safe in ways that push victims even further into the shadows, much more is needed. And I hope to work with colleagues across the aisle to do more to protect programs that stop human trafficking. For these reasons, Mr. Chairman, I oppose 4 of the bills to be considered today and support one of them and encourage my colleagues to do the same. I yield back.
I thank the gentleman. Without objection, all other members who wish to insert written opening statements into the record may do so by submitting them to the committee clerk electronically by the end of the day today. Pursuant to the House rules, a copy of the text to be marked up was made available to members and the public at least 24 hours in advance. The bills being marked up today shall be open to amendment at any point, and the chair will allow members to offer amendments in a manner not prohibited by House or committee rules. Without objection, members who have more than one amendment to the bills and wish to offer their amendments en bloc may do so. The committee will now proceed to consideration of the bill H.R. 1319 for amendment. The clerk, the bill was circulated in advance and printed copies are available. The clerk shall designate the bill.
H.R. 1319, a bill to amend the Fair Labor Standards Act of 1938 and the National Labor Relations Act to clarify the standard for determining whether an individual is an employee and for other purposes.
Without objection, the first reading of the bill is dispensed with. Without objection, the bill will be considered as read and open for amendment at any point, and any amendment offered shall be considered as read. For what reason does Representative Kiley seek to be recognized?
Mr. Chairman, I have an amendment of the desk.
The clerk shall designate the amendment in the nature of a substitute.
Amendment in the nature of a substitute to H.R. 1319 offered by Mr. Kiley of California, identifier Kiley_1319ANS.
Without objection, the amendment shall be considered original text for purposes of further amendment. The amendment in the nature of a substitute has already been distributed. I now recognize Mr. Kiley for 5 minutes to explain the amendment in the nature of the substitute.
Thank you, Mr. Chair. Tens of millions of Americans choose to be independent contractors. They do so because they value the flexibility. They value the ability to choose their own hours and work environment. They choose to be independent contractors for a whole host of reasons. And yet, states like California, principally California, my own state, have enacted harsh anti-worker laws that threaten the livelihood of independent workers, making it, in some cases, nearly impossible to pursue their livelihood by placing severe limits on independent contracting. Indeed, a recent study by the Mercatus Center found in states where these restrictive laws were enacted, traditional employment dropped by 4.7%, self-employment fell by 6.4%, and overall employment dropped by 4.8% when compared to states using a common law standard. In fact, my own state, California, now has the highest unemployment rate in the entire country. On a federal level, studies estimate a total national cost of $17 billion if just 15% of independent contractors are reclassified, and $57 billion if 50% are reclassified. Despite the clear negative effects these laws have, former acting Labor Secretary Julie Su enacted an independent contractor rule that was a California-style ABC test in disguise. The rule used 6 primary factors for an independent contractor to prove their status, but also included unnamed additional factors that could also be used to deem an independent contractor supposedly misclassified. The patchwork of regulations, court decisions, and state laws and rules have made it difficult for independent contractors to trust that the government won't renew their efforts at what one witness aptly termed freelance busting. The Modern Worker Empowerment Act offers a simple solution. The bill would clearly draw the line between independent contractor and employee, giving workers more predictability and job creators more certainty. It amends both the Fair Labor Standards Act and the National Labor Relations Act to clarify exactly where the line is while protecting the flexibility that independent contractors enjoy. It simply restores the common law, common sense, intuitive standard that creators, independent contractors, businesses across a whole host of industries have relied on throughout our history. This amendment, in the nature of a substitute, makes technical changes to the bill, and I urge my colleagues to support the Modern Worker Empowerment Act. I yield back.
Are there any members who wish to be recognized for further discussion? Mr. Scott, you are recognized for 5 minutes.
Thank you, Mr. Chairman. Mr. Chairman, H.R. 1319, the so-called Modern Worker Empowerment Act, would radically rewrite the standard under which workers are classified as employees and thus guaranteed important workplace protections. This bill amends the Fair Labor Standards Act and the National Labor Relations Act to create a significantly narrowed employment test that makes it easy for corporations to misclassify workers as independent contractors or independent business owners rather than their employees. when workers are misclassified as independent contractors rather than employees. They're not simply filling out a different tax form. Misclassified workers are denied a host of workplace rights and protections, including minimum wage, overtime, family and medical leave, right to join and form a union, unemployment compensation, workers' compensation, or access to employee health and pension plans. Misclassification of payroll fraud is already a rampant problem, with as many as 30% of companies illegally labeling some workers as independent contractors in order to cut down labor costs and taxes. Employers do this just to save money, putting those legitimate businesses who follow the rules at a competitive disadvantage. This bill is a roadmap to supercharging misclassification throughout the economy. Any workers who exercise discretion in the way they do their job would be at risk of being misclassified as an independent contractor. So think about the nutritionists who work for healthcare facilities whose job is to tailor make meals individually for patients, or nurses who work at hospitals who routinely make all manner of decisions for patient care, especially in emergencies, or the bartender at your neighborhood pub who might exercise discretion on how to deal with certain customers. There are many jobs where workers exercise control over the way their work is performed, and where bosses may exercise control over the performance more broadly. And under this bill, it would be easy to kick those workers out of employment and labor protections just by labeling them as independent contractors. At a time when over half of Americans are living paycheck to paycheck, rents are skyrocketing, and 40% of Americans don't have retirement accounts, Congress should not be making it easier for companies to exploit their workers and harm their ability to make ends meet. I'm confident that no one has a problem with workers being misclassified as independent contractors if they are truly in business for themselves and can leverage their services to negotiate compensation or the terms of a contract. However, this bill would hurt almost all legitimate independent contractors, like certain truck drivers, by letting companies get away with exerting more control and rules on independent contractors without triggering employment liability. This bill takes us in the wrong direction, which is why I strongly urge my colleagues to vote no on this bill. I yield back.
I thank the gentleman. Are there any other members who wish to be recognized for further discussion on the amendment? There being no further discussion on the amendment in the nature of a substitute, the committee will move to consideration of amendments. Are there any members who would like to offer amendments?
Mr. Chairman, I have an amendment at the desk.
The gentlelady will be recognized for her amendment. The clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to H.R. 1319, offered by Ms. Ansari of Arizona, identifier AMD_03.
For what purpose does the gentleman from Utah seek to be recognized?
Mr. Chairman, I reserve a point of order.
A point of order is reserved. I now recognize the gentlelady from Arizona for 5 minutes in support of her amendment.
Thank you, Mr. Chairman. I agree with the sponsor of this bill on one thing, that our workforce can benefit enormously from flexibility at work. Where we differ is the assumption that flexibility can only be found in independent contracting. There is nothing in labor or employment law that forbids flexibility in work arrangements. Just think of the changes that have, in only a few decades, gone from revolutionary to normal: job sharing, flex time, telework. The only thing standing in the way of a flexible workplace is an inflexible boss. My worry with this bill, though, is that it would endanger all that working families have achieved in their demands for more flexible jobs. Under this bill, someone who has the ability to exercise professional judgment and has wiggle room to decide the details of the way their work is performed could be in danger of being pushed out of the protections our labor and employment laws provide. Obviously, someone who is teleworking does not have a boss looking over their shoulder every second of every day. The bill has a list of factors that may not be used as evidence of an employment relationship. And every single one of those factors is a way that a business could demand more and exercise more control over people who are supposedly independent contractors. My amendment simply adds another factor to that list, that flexible work arrangements cannot be used as evidence either way. Essentially, this amendment makes flexibility a neutral consideration. Independent contractors, of course, enjoy flexibility, but this amendment would make clear that employees can as well. And it protects people who currently enjoy flexible work arrangements in their jobs from potentially being kicked out of employment law, and therefore the benefits they need to support their families. I hope that my colleagues across the aisle will agree that we've come too far to turn back the clock now. Modern workplaces can be very flexible workplaces, and we need to respect that. I urge my colleagues to vote for this amendment, and I yield back.
Does the gentleman from Utah insist on a point of order?
I withdraw my point of order.
The reservation is withdrawn. Does anyone seek recognition on the amendment? For what purposes does the gentleman, ranking member, seek recognition?
I'll move to strike the last word.
The gentleman is recognized for 5 minutes.
Thank you. Mr. Chairman, I agree with this amendment that says that workers should be able to find flexible work, not just when they take a leap to start their own business, but also through employment. We've seen tremendous innovations in the last few decades in flexible employment arrangements, and the rise of software, phone apps, and algorithms creates all kinds of new opportunities for employers to manage their staffing needs with employees who have flexibility to tailor their schedules to fit their lives. So these same tools can give less scrupulous actors the opportunity to misclassify workers as independent contractors. For example, one expert published research on the rise of app-based platforms that enable nurses to choose a hospital shift here or there, but only if they agree to become independent contractors and not employees. There are also apps that do the same for bartenders, hosts, and fry cooks looking for an occasional restaurant shift. These workers have to give up their rights to fair wages and freedom from discrimination. You can't tell me that a nurse working a shift at a hospital or a fry cook in a restaurant is actually a small business. They are unquestionably still employees. Under the bill, however, the hospitals and restaurants could easily escape accountability by pointing out that these workers chose independent contractor life, thus taking the risk of entrepreneurship, and that they manage their so-called business by controlling the schedule. This bill would put employees in flexible work arrangement at risk of losing their rights under the nation's employment and labor laws, and this amendment simply makes clear that workplace flexibility is a neutral factor. It doesn't point to the direction of independent contractor, doesn't mean that you're more likely to be an employee. It's neutral. And so as a result, this amendment will protect the ability of workers to find employment that is flexible, but also protected under the nation's employment laws. So I think this is a good amendment, should be supported, and I yield back.
I thank the gentleman. Are there any other members who wish to speak on the amendment? Seeing no, what does the gentleman from New York seek to be recognized for?
Thank you, Mr. Chair. I move to strike the last word and speak in opposition to the underlying bill, but I will say that I do support the amendment and share Ms. Ansari's views, and would also continue to speak on the underlying bill with this time. I'm concerned about the impact it would have on working people in our national labor policy. This bill makes changes to longstanding labor law in a way that dangerously narrows the definition of employment for certain workers and strips them of protections such as overtime pay, minimum wage, and the right to organize. By changing the test used to classify workers, the bill opens the door for more employers to misclassify their workforce as independent contractors, not because of the nature of their work or that it has changed, but because it helps their bottom line. I was a former union president for almost 8 years, and I worked in a setting where individuals were working as independent contractors, but they were denied benefits at times, and their overtime wages never were delivered to them. Their schedules were changed, their salary was reduced, and these were all without due process. Alongside of them were individuals defined as employees, and they had the same credentials and certification as their fellow individuals, but they had the rights and the protections that were necessary and collectively bargained. I acknowledge that there are individuals who prefer the flexibility and autonomy of independent contractor work. There's certainly nothing wrong with that, and I believe that choice should be respected. But the real risk here is the deliberate misclassification of employees as independent contractors. This is happening far too often across the country, especially in industries like construction, trucking, janitorial and cleaning services, home care, and others. This legislation will only add to the problem. We should remember that the Fair Labor Standards Act was intentionally written with a broad, pro-worker definition of employment that allows for a wide range of factors to be considered by courts and federal agencies. This approach ensures that classification decisions reflect the economic realities of the work rather than rigid legal standards. This bill seems designed to circumvent traditional employment relationships and protections while weakening the enforcement tools available to address misclassification. For those reasons, I oppose the underlying bill and respectfully urge my colleagues to do the same. Thank you, Mr. Chair, and I yield back.
I thank the gentleman. Does anyone else seek recognition on the amendment? If there's no further debate on the amendment, the question is on the amendment by the gentlelady from Arizona. All in favor, say aye. Aye. All opposed, no. No. In the opinion of the chair, the noes have it, and the amendment is not agreed to. Recorded vote has been requested pursuant to the chair's previous announcement. This vote will be postponed. Are there any further amendments to the amendment in the nature of a substitute to H.R. 1319? For what purpose does the gentlelady from Pennsylvania seek recognition?
Mr. Chair, I have an amendment at the desk.
The clerk will designate the amendment.
Amendment to the amendment in the nature of a substitute to H.R. 1319 offered by Ms. Lee of Pennsylvania, identifier AMD_04.
Does the gentleman from Utah seek to?
Mr. Chairman, I reserve point of order.
A point of order is reserved. I now recognize the gentlelady from Pennsylvania for 5 minutes in support of her amendment.
Thank you, Mr. Chair. It's a shame to call this bill the Modern Worker Empowerment Act when it takes away workers' power to rely on the protections of our labor and employment laws by forcing far too many employees to be misclassified as independent contractors rather than employees. But if we truly want to empower workers, we can start by giving them the power to contest their status in a fair forum. Too many workers lack this power due to forced arbitration. I am offering this amendment to ensure that any workers subject to this terrible bill aren't forced to suffer the secondary indignity of forced arbitration. Forced arbitration is when employers force their employees to go to a mediation in a forum the employer chooses before they can file a case in a court to adjudicate their issue. Most employees who are subject to forced arbitration have no idea this clause exists in their employment contract until their employer has wronged them or they're forced to pay mounted upfront fees and prolong the time it'll take for them to seek justice. What's more, studies show that forced arbitration heavily tilts the case outcomes in favor of the boss. For low-wage workers without a union, arbitration is often a death sentence to their efforts to right a wrong committed by their employer. So in a bill that is likely to misclassify many of these workers, let's ensure that they, at the very least, give these workers access to a fair trial in a court of law to challenge whether they are truly working as contractors or if they are actually employees. So I urge my colleagues to support my amendment. Thank you, and I yield back.
Thank the gentlelady. Does the gentleman from Utah insist on his point of order?
Yes, I withdraw my point of order.
The reservation is withdrawn. Does anyone else seek recognition on this amendment? For what purpose does the gentlelady from Oregon seek recognition?
I seek recognition to speak in favor of the amendment.
The gentlelady is recognized for 5 minutes.
Thank you, Mr. Chairman. I'm speaking in support of Representative Lee's amendment today. Arbitration is an alternative to resolving disputes in the court system, and it makes sense when the parties entering into an arbitration agreement have equal bargaining power. That is not the case in an employer-employee relationship typically, and so this amendment I strongly support because it gives workers the rights to have a dispute resolved in a court of law rather than in a forced arbitration. So I just want to support the amendment and encourage my colleagues to do the same, and I yield back.
I thank the gentlelady. Are there any others seeking recognition on this amendment? If not, the question is on the amendment by the gentlelady from Pennsylvania. All in favor, say aye. Aye. All opposed, no. No. In the opinion of the chair, the noes have it, and the amendment is not agreed to. Recorded vote is requested. Pursuant to the chair's previous announcement, this vote will be postponed. Are there any further amendments to the amendment in the nature of the substitute to H.R. 1319?
Mr. Chairman, I have an amendment at the desk.
Ms. Omar, I was just looking around to see where the voice was coming from. So you're
It's early in the morning. I'm not usually this quiet.
You're recognized for 5 minutes on your amendment.
Thank you, Mr. Chairman. H.R. 1319 is a deeply flawed and harmful bill that could strip millions of workers of basic rights and labor protection. The bill essentially states that if a worker is not under a significant control or has entrepreneurial discretion, then they can be classified as an independent contractor. But what does that actually mean? Does a truck driver who just picks a route now qualify as an independent contractor? What about a nutritionist who tailors a diet program? Or a nurse who exercises professional judgment when treating patients or creating their care plan? Under this bill, if you are using everyday discretion and judgment in how you do your job, it could mean that you are no longer considered an employee. That's absurd. My amendment fixes the bill's vague and sweeping language by clarifying that you cannot classify someone as an independent contractor just because they use the kind of routine discretion that nearly every worker does. As written, this bill would give dishonest employers a clear pathway to misclassify workers and avoid labor laws and tax obligations. But this discretion language is not the only poorly drafted or irresponsible section of H.R. 1319. The entire bill is riddled with ambiguous, corporate-friendly language that defies legal precedent and economic realities. It could forcefully convert nurses, bartenders, or delivery drivers into independent contractors with no employment rights. And at its core, this bill will cost millions of Americans, especially low-wage and gig workers, their right to fair pay, overtime, and basic workplace protection. I urge you to support this common sense amendment and to reject this reckless bill. I yield back.
I thank the gentlelady. Does any member wish to speak on the amendment? The gentleman from Virginia, the ranking member, is recognized.
Thank you. Just very briefly, Mr. Chairman, this amendment respects the fact that many employees have jobs that require use of discretion as an ordinary and customary part of the job. Exercising that discretion should not strip them of their rights as employees. And for those reasons and the reasons already expressed, I support this amendment and urge others to do the same.
I thank the gentleman. Does anyone else wish to speak on the amendment? If not, I now recognize myself for 5 minutes. H.R. 1319 provides a clear and simple test in determining whether a worker is an employee or independent contractor. This legislation was introduced on behalf of the millions of delivery drivers, independent truckers, freelance journalists, and many more who choose to be independent entrepreneurs. In addition to the millions of independent contractors in these occupations, there are employees performing some of the same tasks. Despite the partial overlap of duties, there are other clearly defined lines that separate employees from independent contractors. But this amendment would maintain status quo with the regulatory whiplash experienced by individuals operating as independent contractors. For that reason, I will oppose this amendment, and I urge other members to vote no as well. Being that there's no further debate on the amendment, the question is on the amendment by the gentlelady from Minnesota. All in favor say aye. Aye. All opposed, no. No. In the opinion of the chair, the noes have it, and the amendment is not agreed to.
This gentlelady want to vote.
I ask for a recorded vote.
A recorded vote is ordered. Pursuant to the chair's previous announcement, the vote will be postponed. Are there any further amendments to the amendment in the nature of substitute? I recognize the gentlelady from Oregon.
Thank you, Mr. Chairman. I have an amendment at the desk. It is Bonamici AMD 01.
The clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to H.R. 1319, offered by Ms. Bonamici of Oregon, identifier AMD_01.
Does the gentleman from Utah insist on a point of
I
order?
reserve point of order.
Point of order is reserved. I now recognize the gentlelady from Oregon for 5 minutes in support of her amendment.
Thank you very much, Mr. Chairman. H.R. 1319 seeks to change the definition of employment in the Fair Labor Standards Act. This changes who benefits from the minimum wage, who gets to earn overtime pay, and who is protected during break time to pump breast milk. But it also changes the rules around child labor. When the FLSA was passed, child labor was sadly not uncommon in the country. States tried to act on their own to stop it. Groups like the National Consumers League tried to organize consumer pressure to stop it. It took congressional legislation to fundamentally fix the problem. Unfortunately, things have taken an ugly turn in recent years, starting in the first Trump administration and continuing into the early years of the Biden administration. There was a significant increase in child labor violations. According to the Labor Department data, the number of children involved in child labor skyrocketed, nearly 300% from fiscal year 2015 to fiscal year 2024. And these are just the cases that have been detected. We read multiple news investigations of companies illegally employing children in dangerous jobs, story after story of young children working overnight shifts in meatpacking plants, getting burned while handling dangerous chemicals, becoming seriously disabled after falling from roofs that they never should have been on in the first place. And even worse, some states are turning their backs on child labor, weakening or repealing their child labor laws. That's going to put more pressure on the Department of Labor to protect children. But it's coming at a time when the Trump administration is trying to slash the department's budget. Florida Governor Ron DeSantis reportedly suggested that they should increase the number of hours kids can work because they'll need somebody to pick up the slack when immigrant workers are kicked out of the country. The Trump administration's nominee to become the Labor Department's chief lawyer has even recommended that federal rules should be weakened, even when doing jobs that are highly hazardous. But that's not the end of it. We heard Secretary Chavez DeRemer testify here that she wanted to, quote, double down on child labor violations. That's good, but then she turned around and sent OMB a draft rule that's going to change child labor rules. In light of where we've been going, I don't think it's going to be a surprise to anyone if that final rule, when it sees the light of day, turns out to be right in line with the Project 2025 plan. So my amendment draws a line. This bill is unmistakably about weakening workers' rights under the FLSA and the NLRA. And this amendment will at least draw a line and keep the rollback of employment law from rolling over kids. It says simply that the new narrow test for who is an employee does not apply to kids. Our bedrock child labor law should remain as strong as the day it was passed in 1938. So I urge my colleagues to vote for this common sense amendment to protect our nation's children, and I yield back.
Thank the gentlelady. Does the gentleman from Utah?
I withdraw my point of order.
Point of order is withdrawn. Does anyone else seek recognition on the amendment? If there is no further debate on the amendment, the question is on the amendment by the gentlelady from Oregon. All in favor, say aye.
Aye.
All opposed, no. No. In the opinion of the chair, the noes have it, and the amendment is not agreed to.
Mr. Chairman, I request a recorded vote.
A roll call vote is ordered. Pursuant to the chair's previous announcement, this vote will be postponed. Are there any further amendments to the amendment in the nature of the substitute? For what purposes did the ranking member, the gentleman from Virginia, seek to be recognized?
Mr. Chairman, I have a unanimous consent request. Ask unanimous consent that 3 letters be entered into the record in opposition to the bill, one from the Mechanical Contractors Association of America, one from the AFL-CIO, and the other from the Association of Union Constructors.
Without objection, they will be entered. Hearing none, so done. Are there any other amendments to be offered? Seeing there are no further amendments to be offered, we will now move on to H.R. 1320 and open that for consideration. Will the clerk designate the bill?
H.R. 1320, a bill to ensure that the provision of portable benefits to an individual is not considered in determining whether such individual is an employee of a person.
Without objection, the first reading of the bill is dispensed with. Without objection, the bill will be considered as read and open for amendment at any point, and any amendment offered shall be considered as read. Does anyone seek to be recognized? Representative Kiley, for what purpose do you seek recognition?
Mr. Chairman, I have an amendment at the desk.
The clerk shall designate the amendment in the nature of a substitute.
Amendment in the nature of a substitute to H.R. 1320, offered by Mr. Kiley of California, identifier Kiley_1320 ANS.
Without objection, the amendment shall be considered original text for the purposes of further amendment. The amendment in the nature of a substitute has already been distributed. I now recognize Mr. Kiley for 5 minutes to explain the amendment in the nature of a substitute. Mr. Kiley.
Thank you, Mr. Chair. Today I'm presenting a very important piece of legislation, the Modern Worker Security Act, which really goes alongside the Modern Worker Empowerment Act that we just considered. With the rise of service apps and all manner of other forms of self-employment, the number of independent contractors is at an all-time high, and the law really needs to evolve to address these workers' unique needs. While independent contractors might, in some cases, have access to traditional W-2 employee-style benefits separately through another job, through a spouse, many currently cannot access benefits as an independent contractor, and if they do, they, in some cases, actually risk being reclassified as a result, which might even make it no longer viable to pursue their line of work. The Fair Labor Standards Act was originally written for a 1930s workforce that didn't envision the idea that over 70 million Americans would choose to operate independently, or that ride-sharing and food delivery apps would even exist. There needs to be a solution for these workers. And the idea that we're simply going to convert them all into employees, and all 70 million are going to lose their freedom to choose the time and place of their work, and they're all going to have to fit into a pre-assigned shift, that just doesn't work given the nature of our modern economy. The Modern Worker Security Act is a common sense first step to allow independent contractors to access benefits that they can take with them as they pursue different types of work. It provides specifically a safe harbor for those who wish to offer or receive these kind of benefits. So a business will no longer have to worry about the government reclassifying its independent contractors as employees simply because they were provided paid time off or a portable benefits account that they can take with them from each type of work that they do. So this is really important, and I think addresses some of the issues that were just brought up with respect to the last bill that we considered. And when you talk to different types of hiring entities that work with independent contractors, there are a lot who say we would love to be able to extend these type of retirement benefits or healthcare benefits or other kind of benefits to those who work as independent contractors. But if they fear that if they do, that will be used against them in some type of proceeding. It's kind of like no good deed goes unpunished. So this safe harbor is crucially important to enabling these benefits to actually be provided to these workers and so that they have that measure of security. So there are around 15 states that have enacted some form of a benefits program and announced a public-private partnership or debated a proposal in the legislature. And I hope we can build on that momentum with this important bill. The amendment in the nature of a substitute makes technical changes to the bill, and I urge the committee to pass the Modern Worker Security Act. I yield back.
I thank the gentleman. Are there any members who wish to be recognized for further discussion on the amendment and the nature of a substitute? For what purposes does the ranking member, the gentleman from Virginia, seek to be recognized?
Mr. Chairman, I move to strike the last word.
The gentleman is recognized for 5 minutes.
Mr. Chairman, this bill is a curious exercise in solving a problem that does not exist. What the bill claims to do is allow businesses to compensate their independent contractors, not just in cash, but also in the form of some sorts of benefits that they routinely offer to employees. Now, there's no law I'm aware of that prohibits businesses from providing compensation other than to other businesses through a means other than cash if the parties agree to it. The problem is supposedly that offering non-cash compensation will transfer a business relationship into an employment relationship. But the form in which compensation is provided is not mentioned in the multi-factor test used under the Fair Labor Standards Act or the common law control test used in other laws. IRS uses a multi-factor test, and the provision of non-cash benefits such as health and retirement does get a mention in that test, but no single factor determines the result of the test, so that any true arm's-length contracting relationship still should survive the overall test. But what kinds of benefits are being protected? The bill defines portable benefit so broadly that a business could do what one business recently did, namely pay some extra cash into a basic savings account and call that, quote, a portable benefit. That is not prohibited now and does not make an independent contractor an employee. So I urge my colleagues to vote no on this amendment and instead focus with working with congressional Democrats to actually strengthen workers' rights and benefits rather than this, which doesn't appear to do much at all. I yield back.
I thank the gentleman. Are there any other members who wish to speak on this amendment in the nature of a substitute? There being no further discussion on the amendment and the nature of a substitute, the committee will move to consideration of amendments. Are there any members who would like to offer amendments? There being no amendments, the question now occurs on the amendment and the nature of a substitute, H.R. 1320. All in favor say aye. Aye. All opposed, no.
No.
In the opinion of the chair, the ayes have it, and the amendment and the nature of the substitute is agreed to. We'll now move to consider the next bill. For what purpose does the The committee will now proceed to consideration of the bill H.R. 4366 for amendment. The bill was circulated in advance and printed copies are available. The clerk will designate the bill.
H.R. 4366, a bill to clarify the treatment of two or more employers as joint employers under the National Labor Relations Act and the Fair Labor Standards Act of 1938.
The bill was circulated in advance and printed copies are available. The clerk will designate the bill. The clerk has designated the bill. Without objection, the first reading of the bill is dispensed with. Without objection, the bill will be considered as read and open for amendment at any point, and any amendment offered shall be considered as read. Does anyone seek to be recognized? Representative Under, for what purpose do you seek recognition?
Yes, Mr. Chairman, to present H.R. 4366.
The clerk shall designate the amendment in the nature of a substitute.
Amendment in the nature of a substitute to H.R. 4366, offered by Mr. Onder of Missouri, identifier Onder _ 4366 _ ANS.
Without objection, the amendment shall be considered original text for purposes of further amendment. The amendment in the nature of a substitute has already been distributed. I now recognize Mr. Onder for 5 minutes to explain the amendment in the nature of a substitute.
Thank you, Mr. Chairman. The Biden-Harris administration spent the last 4 years causing mayhem for job creators and workers across America. They adopted a rule that significantly affected the franchise industry and virtually any industry with contractor-subcontractor relationships. In doing so, the Biden administration reversed the traditional standard of finding joint employer status only when the franchisor exerted direct and immediate control over the franchisee's employees, disrupting the franchisor-franchisee relationship. Traditionally, franchisees are small businesses that receive limited services and support from the franchisor. Under the Biden rule, one business is considered to be the joint employer. Could be considered to be a joint employer of the other business if the two entities share or jointly determine their employees' essential terms. Under the traditional rule, one business is the joint employer of another business's employees if the two entities share or jointly determine their employees' essential terms and conditions of employment. What does this mean? It means more NLRB determinations favoring joint employer status. It means thousands of job creators share legal liability for the actions of businesses that do not actually supervise, or even employees they do not actually supervise or see day to day. It means small business owners, independent contractors, and the franchise industry suffering under the rules of the Biden-Harris administration. That is why I'm proud to speak in favor of H.R. 4366, the Save Local Business Act, which amends the National Labor Relations Act and the Fair Labor Standards Act to consider a company to be a joint employer if it shares employees with another entity and directly, actually, and immediately exercises significant control over the essential terms and conditions of employment for those shared employees. This direct and immediate control standard mirrors the 2020 rule from the first Trump administration and does constitute the traditional standard. The bill also makes sure that control means control. A business has control over workers if it can hire and fire them, discipline them, decide how much to pay them and what benefits to offer them, supervise them day to day, and assign their work schedules, positions, and tasks. I thank Representative Comer for his leadership on this important bill, and I urge adoption of the amendment in the nature of a substitute, which makes a technical change to the bill. I yield back.
I thank the gentleman. Are there any members who wish to be recognized for further discussion on the amendment in the nature of substitute? Representative Scott, do you wish to be recognized?
Thank you. I move to strike the last word.
You are recognized for 5 minutes on the bill.
Thank you, Mr. Chairman. Mr. Chairman, the Save the Local Businesses Act would eviscerate workers' rights and protections under the National Labor Relations Act and the Fair Labor Standards Act by allowing large corporations to evade accountability when they violate labor and employment laws, such as by stealing workers' wages, hiring children for dangerous jobs, and firing pro-union workers. It would also weaken the ability of workers' unions to negotiate a fair and full contract, improving their working conditions. This bill has been considered by this committee time and time again, and the reality of its impact remains the same. It's bad for working people, and it's bad for small businesses who could be left liable for another employer's action. The labor and employment laws have long protected workers who have joint employers, which is when more than one entity controls the terms and conditions of employment. Strong joint employment standard under the NLRA ensures that workers can collectively bargain with the parties that actually control the terms and conditions of employment. If one is hired by a temp agency, which then contracts with a work site to provide employees, and that work site in that contract sets the salary, the contract, it is useless for the union to try to negotiate a salary increase with the temp agency. They're locked in. It's the work site that set the salary. So if you're not able to negotiate with the joint employer, you don't really have any right to negotiate. The pro-worker joint employment standard under the FLSA ensures that appropriate companies can be held accountable for violations pertaining to everything from wage theft to equal pay to oppressive child labor. Joint employment is becoming more common with the rise of what they call fissured workplace, where firms increasingly use overlapping agreements of contracting, subcontracting, and temp agencies, which has weakened workers' bargaining rights and allowed large corporations to avoid bargaining and liability for violating labor laws. Millions of Americans, including janitors, housekeepers, cooks, and many others who are employed through some contractors or temp agencies, are at risk of being exploited by employers trying to evade liability through workplace fissuring. And the bill we are considering today would make the problem worse. H.R. 4366 radically rewrites both the NLRA and the FLSA by adding new, narrow definitions of what is a joint employer. Under the legislation, a person may be a joint employer only if they directly and actually and immediately exercise significant control over specific terms of employment, including hiring, firing, and determining rates of pay and benefits, day-to-day supervision, assigning work schedules, positions and tasks, and administering discipline. If an entity controls all of these terms except one, then they may not be a joint employer under the definition. And even if the entity determines rates of pay, it may not be liable for wage theft under the FLSA if they don't meet the other standards. Alternatively, the entity could have control over all the terms, but if it exercises that control indirectly through the subcontractor, then the entity may still be immune from any liability under this bill. Under the NLRA, this would cripple a union's right to negotiate with entities that actually control the terms and conditions of work. Even more alarmingly, under this bill, it could be the case that employees have no employers who are liable for wage violations. That's because no employer met all of the conditions to be a joint employer. That could set off chaos and impose needless harms to workers trying to navigate our legal system. To put into context how this bill empowers large corporations and the working people, the Economic Policy Institute estimated that a similar NLRB regulation that was finalized under the first Trump administration would transfer $1.3 billion each year from workers' paychecks to their bosses' pockets. This not only does this bill protect large companies at the expense of workers, it could also hurt small businesses. This bill would insulate large franchisors from liability while leaving franchisees solely on the hook for decisions required by the franchisor. If the franchisor mandates a policy that could violate the NLRA or FLSA, the franchisee is forced to accept shared control without shared responsibility. We should be standing up for workers and small business owners, not passing legislation that makes it easier to exploit them. So I urge my colleagues to vote no on the bill and yield back the balance of my time.
Gentleman's time has expired. Are there any other members who wish to be recognized? The gentlelady from Oregon, do you wish to be recognized?
Yes, Mr. Chairman, I'd like to speak in opposition to the amendment and the nature of the substitute. Thank you, Mr. Chairman. I first want to align myself with the comments of Ranking Member Scott. We've had this discussion in this committee over the years many, many times, and I always listen very carefully because before I came to Congress, before I served in the state legislature, I was a lawyer and I represented franchisees in disputes with franchisors. So I always listen to this carefully because we always hear that the sky is falling and people won't be able to open franchises and franchisors will be considered employers. But they aren't unless they assume general control over the management of the franchisee's employment. And when they do that, they should be considered an employer. So I frankly get a little frustrated with the sky is falling argument that this is going to discourage people from and opening small businesses and opening franchises, because it doesn't happen unless the franchisor acts like an employer. And as Mr. Scott said, when they do that, they should be held responsible. So I'm going to vote no on this amendment and hope someday that we can stop the same argument over and over again, because it's not hurting small businesses. In fact, passing this bill will hurt small businesses, as Mr. Scott said, if they are held responsible, as if they're required to do something by their franchisor that violates the law. So I oppose this, and I yield back the balance of my time.
I thank the gentlelady. Are there any other members who wish to speak on this amendment? I recognize myself to speak on this bill. The bill's definition of joint employment, I believe, provides a clear, specific, common-sense standard that will reverse the damage done to businesses by the Obama and Biden administrations. H.R. 4366, as it sits in the nature of a substitute, provides clarity and certainty for employers and employees alike, amending the National Labor Relations Act and the Fair Labor Standards Act to adopt a definition of joint employer that grounds the standard in the actual conduct of the employer and the actual relationship between the parties. The Obama-Biden indirect or reserved control standard for joint employment is an unworkable compliance nightmare for employers by creating confusion and ultimately undermining the franchise business model. In order to avoid liability for the actions of workers, they don't actually supervise or control. Contractors and franchisors under the Biden joint employer rule are forced to reduce the connections and resources they offer to subcontractors and franchisees. The consideration of indirect control makes business owners less likely to create jobs through subcontracting and causes franchisors to eliminate assistance to franchisees, such as employee handbooks and job applications. The Obama-Biden harmful joint employer standard puts hundreds of thousands of businesses at risk, including thousands of franchise operations. I urge my colleagues to vote yes on H.R. 4366 and save their constituents' local businesses. And I yield back. Are there any others that wish to speak? For what purposes does the gentleman from Missouri wish to be?
Yeah, to speak briefly.
I recognize the gentleman from Washington.
Thank you, Mr. Chair, and I'd like to yield my time to Congressman Under.
Thank you for yielding time. I'd just like to point out that the direct and immediate control standard for joint employment in the franchise or franchisee context is not in any way a radical new standard. In fact, it was the standard that prevailed for over 30 years, including the first 7 years of the Obama administration until the Browning-Ferris Industries decision by the NLRB in 2015. So this really restores, as the chairman pointed out, a common sense standard to this joint employer relationship, and I yield back.
I thank the gentleman. Are there any others who wish to speak on the bill in nature of a substitute? There being no further discussion, amendments are in order. Are there any who wish to offer an amendment?
Yes, Mr. Chairman.
I recognize the gentlelady from North Carolina.
Thank you, Mr. Chairman. I have an amendment at the desk, 529.
The clerk will designate the amendment.
Amendment to the amendment in the nature of a substitute to H.R. 4366, offered by Ms. Adams of North Carolina, identifier Adam NC _529.
From Utah, wish
I
to...
reserve a point of order.
Point of order is reserved. I now recognize the gentlelady from North Carolina
Thank you, Mr.
5
Chairman.
minutes in support of the amendment.
Thank you, Mr. Chairman.
Mr. Chairman, could the clerk read the amendment? Because I have a different designation than the one I'm looking at. I think it's short.
The clerk will designate the amendment again.
Amendment to the amendment in the nature of a substitute to H.R. 4366, offered by Ms. Adams of North Carolina, identifier Adam NC_529.
Could you read the amendment?
Yes. Page 2, line 16, insert after the first period the following. In the case of a violation of Section 12 relating to child labor, this paragraph shall not apply.
Thank you.
I now recognize the gentlelady from North Carolina for 5 minutes in support of her amendment.
Thank you, Mr. Chairman. This bill turns back the clock on employment law. And in the course of doing that, it will turn back the clock on child labor. As some of you know, I was a college professor for 40 years, so let me give you a little history lesson. When Congress developed the Fair Labor Standards Act in 1938, it deliberately crafted the broadest definition of employment possible. Among other things, the drafters of the FLSA had learned the lessons that state policymakers addressed when tackling the problem of child labor in sweatshops. One common form of abuse was called inside shop. In a factory in the early 1900s, you might find workers who were employed directly by the factory, working side by side with workers who were employed inside the factory by a labor contractor. For example, a metal fabricating plant might consist of several departments, each of which was like a shop inside a shop run by a contractor. Through arrangements like this, a big firm would benefit from the work of child labor, but it would try to evade responsibility by arguing that the inside shop or a labor contractor was to blame. The child labor laws of the late 1800s and early 1900s were written to account for these arrangements. They used the same language that we have now in the FLSA so that they could hold accountable not just the parties who were directly in charge of child laborers, but also all the parties who permit children to work in violation of the law. So this bill will narrow the definition of employment in the FLSA, and I fear that children could be harmed as a result. No business should benefit from illegal child labor, period. But everywhere we turn today, Republican policymakers seem eager to turn back the clock on child labor. A dozen states have eliminated or weakened their child labor rules in recent years. The Project 2025 roadmap for the Trump administration calls for doing the same thing with federal child labor rules, including the rules that prohibit children from working in hazardous jobs. In fact, the author of that recommendation has been nominated to serve as a senior Labor Department official. And right now, sitting in the White House regulatory office is a draft rulemaking that will change federal child labor rules. And I can't help but see a pattern. House Republicans seem hell-bent on destroying the Department of Education and promoting private school vouchers to subsidize education for the wealthy. And at the same time, bills like these seek to roll back the clock on child labor. My colleagues on the other side of the aisle, whether they admit it or not, are pursuing a legislative agenda that will create a two-tiered childhood, a childhood where the wealthy enjoy well-equipped publicly subsidized private schools, while poor children are pushed into dangerous jobs. And so my amendment will ensure that the changes in this bill would not only apply to child labor cases. I urge members to vote for this amendment, and Mr. Chairman, I yield back.
I thank the gentlelady. Does the gentleman from Utah insist on a point of order? Point of order is withdrawn. Does anyone else seek recognition on the amendment? Representative Scott, do you seek recognition?
Thank you, Mr. Chairman. I move to strike the last
You're
word.
recognized for 5 minutes.
Mr. Chairman, this amendment reflects our view that it is important that we prevent this bill from rolling back our child labor laws. Changing the definition of employer in the Fair Labor Standards Act changes who is responsible for providing minimum wage and overtime pay, but it also changes the rules around child labor and who is responsible for child labor law violations. Congress knew how important it was to ensure the broadest possible liability for child labor. So according to the framers of the FLSA, the definition was said to include those who, quote, suffer or permit a person to work. Suffer and permit extends accountability to those who are in a position to know whether work is happening and choose to allow it to happen. This language means that if you're a factory owner and a labor contractor who provides workers, including child labor, then the factory owner who benefited from the illegal work of children is on the hook, just the same as the contractor who actually directly controlled the work. It appears that the Trump administration is poised to issue new rules to weaken our child labor laws, but we have to hold the line to ensure that the law is not weakened. So I urge my colleagues to support the amendment and yield back the balance of my time.
I thank the gentleman. Does anyone else seek recognition on the amendment? The gentlelady from Georgia is not recognized. If there's no further individuals seeking to be recognized on the amendment, we now move to the amendment of the gentlelady from North Carolina. All in favor say aye.
Aye.
All opposed, no. No. In the opinion of the chair, the noes have it, and the amendment is not agreed to. Is the record roll call requested? Recorder vote is requested. Pursuant to the chair's previous announcement, the vote will be postponed. Are there any further amendments? Being no further amendments,
Mr. Chairman.
for what purpose does the gentleman from Virginia seek to be recognized?
Chairman, to ask unanimous consent that letters in opposition to the bill from the National Employment Law Project and the Signatory Wall and Ceiling Contractors Alliance be entered into the record.
Without objection, they will be entered. The committee will now proceed to consideration of the bill H.R. 4312 for amendment. stated, the committee will now proceed to consideration of the bill H.R. 4312 for amendment. The bill was circulated in advance and printed copies are available. The clerk shall designate the bill.
H.R. 4312, a bill to protect the name, image, and likeness rights of student athletes and to promote fair competition with respect to intercollegiate athletics and for other purposes.
Without objection, the first reading of the bill is dispensed with. Without objection, the bill will be considered as read and open for amendment at any point, and any amendment offered shall be considered as read. Does anyone seek to be recognized? Chairwoman McLean, for what purpose do you seek recognition?
Mr. Chairman, I have amendment at the desk, amendment HR 312A-N-01.
The clerk shall designate the amendment in the nature of a substitute.
Amendment in the nature of a substitute to H.R. 4312, offered by Ms. McLean of Michigan. Identifier McLean _4312_ANS.
Without objection, the amendment shall be considered original text for purposes of further amendment. The amendment in the nature of a substitute has already been distributed. I now recognize Chairwoman McLean for 5 minutes to explain the amendment in the nature of a substitute.
Thank you, Mr. Chairman. College athletes are in a transformational period driven by the introduction of name, image, and likeness rights and the finalized House versus NCAA settlement that allows schools to share revenue directly with student athletes. We all agree that student athletes deserve to be compensated for their contributions to college athletics. But the current environment is unsustainable and risks exploitation of student athletes. The absence of uniform NIL regulations across states, coupled with ongoing antitrust litigation and attempts to classify student athletes as employees, has created regulatory concerns. The ongoing lawsuits have the potential to fundamentally alter the financial structure, operational framework, and governance of college athletics. This will create substantial implications for the NCAA, its member institutions, and the availability of academic and athletic opportunities for thousands of student athletes. It is time to bring stability to college sports, which is why I'm excited that the committee is moving H.R. 4312, the Student Compensation and Opportunity Through Rights and Endorsements, the SCORE Act. The SCORE Act establishes a national framework for college athletics, protects student athletes' rights to NIL deals with reasonable guardrails in place, resolves state law disparities, and puts an end to the ongoing litigation environment hovering over all collegiate sports. Additionally, H.R. 4312 clarifies that student athletes are not employees. Designating student athletes as employees would risk a reduction in benefits for student athletes and reduce athletic opportunities. Currently, student athletes are receiving more benefits than ever between scholarships, NIL deals, and now revenue-sharing payments. The NCAA estimates compensations to student athletes is approaching 50% of total athletic revenue at its schools. My amendment, H.R. 4312, further protects student athletes by requiring clear written agreements for NIL deals and establishing a database of registered agents to protect student athletes from being exploited. Additionally, my amendment adds a requirement that any school accepting student athletes from the transfer portal must provide written disclosure of accepted academic credits before the student athlete transferred. My amendment increases protections for smaller institutions by ensuring that all college sports governing entities establish advisory councils composed of every conference member, and that those governing entities include students, particularly those from smaller institutions on decision-making bodies. Lastly, this amendment strengthens compliance with the Act through stronger enforcement mechanisms, including tying institutional requirements to federal student aid funding under the Higher Education Act and authorizing state attorney generals to address NIL violation. By establishing a sustainable framework, H.R. 4312 and my amendments provide stability for the governance of collegiate athletes, support a broad array of athletic opportunities, and ensure long-term stability for this vital piece of American culture. I urge my colleagues to support this amendment and the underlying bill. And with that, Mr. Chairman, I yield back.
I thank the gentlelady. Are there any members who wish to be recognized for further discussion on the amendment and the nature of a substitute? For what purpose does the gentleman from Virginia, the ranking member, seek to be recognized?
Mr. Chairman, I move to strike the last word.
The gentleman is recognized for 5 minutes.
Mr. Chairman, college athletics has become a multi-billion-dollar industry. In the last fiscal year, the NCAA alone brought in almost $1.4 billion in revenue, a $91 million increase over the prior fiscal year. And it's not just the NCAA that's prospering. In 2023, the NCAA's largest athletic conferences collectively generated over $3.5 billion in revenue, while Division I schools reported nearly $19 billion in revenues from athletics. Let's be clear, success we're seeing today was built off the hard work and talent of college athletes. Yet despite the flow of billions of dollars to the NCAA, athletic conferences, and member schools, college athletes do not share in the prosperity their efforts and performance creates. For example, in a 2019 survey, almost 25% of the D1 college athletes reported struggling to get enough food in the last month, and nearly 14% were homeless over the last year. On the other hand, in 2023, D1 schools spent over $3.6 billion on coaches' salaries, making up the largest spending category of these schools' athletic budgets. Athletes are also putting in long hours into their sport on top of their classes or another job. Others deal with harassment and abuse and experience minor and major injuries. With this in mind, Congress should be working to uplift and protect the college athletes. Unfortunately, that's not what we're doing today. The legislation we're debating today, the SCORE Act, is promoted as a measure to empower college athletes, when in reality it is a series of blank checks and bailouts to the NCAA. One of the most egregious provisions in the SCORE Act is a permanent ban on college athletes receiving labor and employment rights under any federal or state laws. Our nation's labor and employment laws rely on fact-specific tests and are determined on a case-by-case basis in one way or another. Instead of letting a few court cases play themselves out to determine if certain groups of college athletes, let alone all of the athletes, meet the definition of employee under specific laws, Republicans in this bill are seeking to jump the gun and eliminate potential labor rights and protections, including rights to minimum wage, right to organize, right to bargain for fair conditions. It also eliminates workers' compensation for injuries or disabilities. The bill does this by limiting the responsibility for injuries that may be caused by participating in the sports. They may cause permanent disabilities. Workers' comp laws would have addressed those permanent disabilities, but this bill eliminates that possibility. I'm deeply concerned that this provision will open the door for further exploitation because it means that no matter the control or conditions imposed on college athletes' lives, the schools, conferences, and NCAA will never have to worry about triggering employment liability. I'm also deeply concerned about the SCORE Act's unprecedented preemption provisions, which would not only eliminate any college athlete protections put in place by states, but forever prohibit states from doing so in the future. This bill would further require certain colleges to provide student athletes with academic and career support and financial aid. Although supporting students' success is very important, these requirements heavily align with what the NCAA already requires its members to provide and allows colleges to outsource the services right back to the NCAA. Ultimately, these loose requirements fall short of meaningfully addressing the educational, health, and financial needs of student athletes. The bill also requires colleges to publish how they use student athletic fees and restrict high media revenue colleges from and restricts high media revenue colleges from charging students such athletic fees. While I appreciate the efforts to increase transparency regarding on how colleges use students' tuition and fees, I have concerns about making changes to this student fee outside of a more holistic price transparency reform and without fully understanding the potential administrative and financial impacts on colleges. And as the Democratic Women's Caucus has reminded us in a recent letter, this bill does not require Title IX equity in name, image, and likeness programs, and if enacted as drafted, would actually exacerbate already existing financial inequities between men's and women's athletic programs. And finally, Mr. Chairman, whatever rights the athletes retain under the bill appear to be unenforceable, and as everyone knows, the right without a remedy is no right at all. And so for these reasons, I urge my colleagues to oppose the legislation. You're back.
I thank the gentleman. Now I recognize the gentleman from Washington for 5 minutes.
Thank you, Mr. Chair. I greatly appreciate the committee taking up this important issue and the sincerity of the underlying substitute bill in trying to bring some stability to a very chaotic and troublesome college sports landscape. But in its current form, this is the wrong solution at the wrong time. And if this bill were to be voted into law, it would exacerbate the demise of the policy benefits to the American people of what college athletics should be. So just to understand the flaws of this bill, it is based on a flawed House settlement. And to remind everybody where we are in college sports, when the Supreme Court with the Kavanaugh ruling ruled that college athletes were not amateur, it set off a predictable pay-for-play scheme amongst supporters of competitive college athletics, primarily in football and basketball. And with no restrictions on transfers, you essentially got unfettered free agency with no salary caps, and chaos has ensued. Against that chaos, there were trial lawyers looking to get at all the money in big-time college football, and when they launched the House settlement, the deepest pockets that could defend that lawsuit were primarily from the SEC and the Big Ten, the richest conferences, and they came up with this flawed settlement that has at its heart a salary cap that would only the largest schools can reach. And what will be the impacts of that salary cap that only a few schools can reach is that our schools are seeking to be competitive in football or keep up in football and basketball. They will throw to the side Olympic sports, either in style or, more importantly, in substance, and what happens underneath. This bill also does not specifically address Title IX. The workaround to Title IX is to determine that the value of college athletics is related to TV market share. And that is not something that Congress should be ratifying. What Congress should be doing is recognizing that the entities involved in college sports are not capable of governing themselves. The NCAA has become a feckless, powerless institution. The schools are very controlled by their richest donors, and the states seek, through their legislatures, to pass laws to benefit their schools. And driving the bus now, more than anyone, are the commissioners of the SEC and the Big Ten and TV executives at ESPN and Fox Sports. College athletics is extremely important to our nation's higher educational landscape. It has impacts on student athletes, has economic impacts on communities. If you look at the demographic cliff of what's going into colleges, some schools very much need just athletic opportunities to attract and recruit students. And if you look at a time when there is more money than there has ever been in college athletics, and yet there are less opportunities for the high school graduates, the sons and daughters of America, to compete in sports, you say this situation is really broken. So there should be a better solution. It should be a solution that should fundamentally consider the issues of student-athlete welfare, academic purpose, competitive balance, and sustainability in Olympic sports. And on all those measures, the underlying SCORE Act comes up short. Over the past weekend, I have reached out to 15 athletic conferences. A couple of them support the SCORE Act. Many of them have concerns. I would like to, Mr. Chair, if I may, enter into the record letters from 3 entities. One is the U.S. Olympic Committee expressing concern with the SCORE Act. Another is from the chairman, the commissioner of the Big West Athletic Conference expressing concern. And the final letter is a letter from 5 attorney generals expressing concern, if I could enter these into the record.
Without objection, they will be entered.
Thank you, Mr. Chair. So college sports should be, colleges are highly subsidized public goods. College sports should be regulated as such. It's time for Congress to set up a body that can deal with this holistically, not outsource this to a flawed House settlement. There's a better approach out there, and I would urge at this time this bill be withdrawn so we can work on a better solution.
Gentleman's time has expired.
Thank you.
Recognize the gentlelady from Georgia, Ms. McBath.
Thank you, Mr. Chair. I wish to speak in opposition of the amendment in the nature of a substitute.
You're recognized.
Thank you. College athletics have such an important place in our education system in American society, even as my colleagues on the other aisle have just recognized and spoken up, especially though in my home state of Georgia, I represent Georgia, and players represent more than just, it's more than just a sports team to Georgia. It's kind of like, it's in our blood, it's in our nature, and they carry the legacy of a town, an institution, and a lot of times the players' dreams and their accomplishments. These things are incredibly meaningful, and we need to be sure that nothing we do here will further complicate things for folks back home or put opportunities further out of reach for students and for their families that are depending on these opportunities. Student athletes must be treated with the dignity and the respect that they absolutely deserve. They must be fairly compensated for their efforts while ensuring that schools, both large and small schools, can continue to provide high-quality educational and athletic opportunities for our students. Athletic scholarships play a very important role in making sure that every student who wants to better themselves through higher education has an opportunity to do so without going into a lifetime of debt, regardless of how much money their parents make or whether anyone in their family has ever been to college before. They are directly responsible for helping people lift themselves up from lower income levels and into a better quality of life, sometimes breaking generational cycles of poverty. While most student athletes will not go on to play a professional game as a career, they will all the more likely still graduate. They will be more likely to gain the skills that are necessary to provide a decent life for themselves and for their families or whatever profession if they decide to pursue after college. Athletic scholarships are true engines of social mobility, and we must ensure that they are kept widely available for both males and female sports and for sports of all kinds, not just those that generate revenue. The U.S. Olympic and Paralympic Committee sent a letter to this committee stating that, and I quote, proposed legislative reforms could result in potential for widespread program cuts or material reductions in the investment level that could dismantle decades of progress in sport diversity and opportunity, end quote. The unfortunate reality is that some smaller schools are already cutting their sports programs and the scholarships that may come along with them, and we must take action in this body to prevent that from becoming the norm. However, this proposal, I'm sad to say, does not do that. The SCORE Act also fails to include specific Title IX protections for women's athletics at a time when women's sports are increasing in popularity. There are just three lines in the current ANS about Title IX, And we must ensure that any legislation that we sign ourselves onto and sign into law will protect women's athletics as well as the schools that offer these opportunities to women. I look forward to supporting bipartisan legislation that will put student athletes first, protect the sports that we know and that we love, and preserve opportunity for all students, regardless of what sport that they play or the school that they choose to attend. I do encourage all of my colleagues to oppose the ANS and engage in good faith for us to come up with a proposal, or let's work together, for a proposal that gets this right for the students and the families who can't afford for Congress to delay on this issue any longer, and I yield.
I thank the gentlelady. I now recognize Representative Courtney, the gentleman from Connecticut.
Thank you, Mr. Chairman. Strike the last word. Again, I think the thoughtful comments by both sides on this measure really, I think, have been really helpful in terms of fleshing out the vote we're going to be taking soon. I would note that this bill does not have sole jurisdiction here in the Education and Workforce Committee. The Energy and Commerce Committee is doing a parallel markup at the same time. And I, in my estimation from talking to some of the members on that committee, that the level of sort of integration and communication between the two has been somewhat deficient, and really, I think to get a good package, really I think this really still needs a lot more work, and that was suggested by the gentleman from Washington State. And at least to that extent, that I think it's a measure that is tricky and really carries a lot of different sort of challenges that more work needs to be done. One glaring issue, which again ENC is not going to be taking up in terms of the NIL issue, is the fact that international students who today are definitely part of Division I athletics and actually Division III athletics, because a lot of state universities and colleges and universities are now recruiting overseas. I think that's a terrific thing. At the University of Connecticut, the most valuable player in the Final Four, 2023, Adama Sanogo from Mali, again, was just a sensation in terms of UConn winning the title that year. Because he, again, is from Mali, he is not able, or was not able, to participate in NIL. Same thing was true with the women's basketball team, Nika Mule and Aaliyah Edwards. Aaliyah Edwards was from Canada. Nika Mule was from Croatia. Again, starting players on the team that went all the way to the Final Four. Their American counterparts were participating in NIL, but the fact that they, again, were not American citizens, they were barred from benefiting from the NIL program. Again, I think that that is just a glaring unfairness. I mean, the word fairness is in the title of this bill, and if we really are going to talk about trying to stabilize and make the program more equitable, the reality of the fact that colleges and universities are recruiting overseas because they want the best of the best. Again, I think that's a compliment to things like basketball, which were invented in America, that people want to come here to play at the highest level, that it really has to be sort of part of the reality of this legislation when we're dealing with it. It, again, has been completely left out in the deliberations in both the ENC committee and the Education and Workforce Committee, and again, I think that really should be troubling to the members of this committee, that something like that, which again has been all over sports radio and all over the media, that international students whose names we all know, in our states and watching competition, on TV and other media sources, again, are not part of the NIL program that's there. There are other issues which I'll be addressing with some amendments, and I know some of my colleagues on this side of the aisle are going to be addressing them. It's not really hopeful or encouraging that necessarily those are going to be adopted as part of the bill. And again, I think that it's an important issue. It deserves really serious effort. It should be bipartisan, and it should be all-inclusive in terms of the scope of issues that, since the court decision was announced, have already emerged. So again, at this point, I'm certainly not going to be supporting the final outcome based on the manager's amendment. Want to, again, tip my hat to the fact that the sponsor has approached this with seriousness, but there's a lot more work that remains to be done. I yield back.
I thank the gentleman. Are there any others who seek to speak on this amendment in nature of a substitute? There being no further discussion on the amendment in nature of substitute, the committee will move to consideration of amendments. Are there any members who would like to offer amendments? I recognize the gentleman from Connecticut. For what reason do you wish to be recognized?
The clerk has an amendment at the desk.
The clerk will report the amendment.
Amendment to the amendment in nature of a substitute to H.R. 4312, offered by Mr. Courtney of Connecticut, identifier COURTN_024.
Does the gentleman from Utah wish to reserve?
I reserve point of order.
A point of order is reserved. I now recognize the gentleman from Connecticut for 5 minutes in support of his amendment.
Thank you, Mr. Chairman. As the amendment visibly shows, it's a very simple, straightforward amendment that literally substitutes one word on page 21 of the bill, which talks about, again, the availability of medical care for injuries suffered by student athletes. And the bill, to its credit, recognizes that a student who suffers an ACL injury or Achilles tendon injury or some other sports-related injury would get some period of time of coverage medically following graduation. The bill calls for 3 years of medical coverage for students who experience those injuries. My amendment would extend that period of coverage from 3 years to 10 years. Again, we're talking about student athletes who, again, can suffer an injury which could be permanent. As a result of a collision in football, or making too quick a pivot in basketball or soccer, and a torn ACL or a broken bone can cause again a need for longer-term care than I think what the base bill contemplates. Of 3 years following graduation or separation. Again, there's instances where some athletes who suffer an ACL make a quick recovery. Paige Beckers has had 2 ACL injuries playing for the UConn women, and now she's doing terrific in the WNBA. But there are other instances where ACL injuries have really literally ended athletic careers and really have created a lifetime sort of permanent issue and problem, which I think is we should not sort of cut off with a 3-year cap, which is what is in the base bill. Again, we're talking about not comprehensive health insurance. We're talking about literally medical care for a specific injury. It's sort of comparable to a workers' compensation claim, where, again, medical coverage through workers' comp is only extended to the work-related injury. This section of the bill is talking about sports-related injuries only. So the burden in terms of colleges and universities, which are already going to have to carry 3 years of coverage, under my amendment would be extended to 10. And again, you could argue that you could go less or more, but certainly 10, I think, is a fair amount for an 18-year-old or a 19-year-old who suffers an injury playing sports in college and universities, and therefore I think it's reasonable, and I would ask the members to support the amendment and yield back.
I thank the gentleman. Does anyone else wish to? Does the gentleman from Utah?
I withdraw my point of order.
Point of order is withdrawn. Does anyone else seek recognition on the amendment? I recognize the gentleman, ranking member from Virginia, Mr. Scott.
Thank you, Mr. Chairman. Mr. Chairman, the SCORE Act would broadly take away athletes' rights to get access to courts for matters under the Act, but it provides some coverage for athletes who are hurt in the course of their athletic activity. In exchange for giving up their rights, they get guaranteed compensation. That's the same kind of deal we have in workers' comp, where you give up your right to, if you're injured on the job, you give up your right to sue your employer, but regardless of fault, regardless of whether you could have won a suit or not, you have access to health care and lost wages as a result of the injury. But what the SCORE Act provides in the case of injury is stingier than even the stingiest workers' compensation law. In the bill, medical coverage would end 3 years after graduation. This amendment would extend that to 10, but it could be cut off earlier if the student is expelled by code of conduct violations. By contrast, workers' comp typically allows for medical coverage for the duration of the work-related injury, including benefits that could last permanently for permanent disabilities. The 3-year duration under the bill omits any coverage for sports-related conditions that may manifest clinically, like CTE, years down the road. The bill offers no income replacements for athletes who are permanently disabled, doesn't offer death benefits or survivor's benefits in the case of fatal sports-related injuries. But you could go on, but the point is you take away the student's rights to be protected and don't even get as much as you do under workers' comp. This amendment doesn't fix that, but it goes a long way in helping modify some of the problems with the 3-year limitation. And so I would support the amendment and urge my colleagues to do the same.
I thank the gentleman. Does anyone else seek recognition on the amendment? I now recognize myself for 5 minutes in opposition. I appreciate Representative Courtney's intent to enhance long-term medical protections for student athletes injured during competition. Section 5 of the SCORE Act and current NCAA core guarantees already ensure robust medical coverage for athletics-related injuries during enrollment and for 3 years post-graduation, sufficiently addressing most student-athlete health needs. Extending coverage to 10 years places significant financial strain on universities, many of which already face tight budgets. The added costs of 10-year medical coverage will likely reduce athletic opportunities as institutions may cut non-revenue sports or limit scholarships to offset expenses, undermining the SCORE Act's goal of supporting broad-based athletic participation. That said, we're all interested in protecting student athletes, so I'm happy to work with the gentleman from Connecticut on this issue as the bill moves forward. I oppose the amendment as written and yield back. There being no further debate on the amendment, the question is on the amendment by the gentleman from Connecticut. All in favor say aye. Aye. All opposed, no. No. In the opinion of the chair, the noes have it and the amendment is not agreed to. A recorder vote has been ordered pursuant to the chair's previous announcement. This vote will be postponed. Are there any further amendments to the amendment in the nature of substitute to H.R. 4312? For what purposes the gentleman from Washington seek recognition?
Thank you, Mr. Chair. I have 4 amendments. I think perhaps we could entertain my first amendment and then back to Congressman Kiley, if that was all right.
Would the clerk identify the amendment?
Amendment to the amendment in the nature of a substitute to H.R. 4312, offered by Mr. Baumgartner of Washington, identifier BAUMGA_020.
The gentleman is now recognized for 5 minutes.
Thank you, Mr. Chair. Well, this amendment gets at fundamentally what does Congress want college athletics to be. In the flawed House settlement, and you have to understand, in college sports, there's not a lot of money in college sports. There's a lot of money in big-time football in college sports. In the flawed House settlement, when the trial lawyers were going after the football money and the big football schools had the deepest pockets to defend the lawsuit, they set up this House settlement that was a bit of a power grab, both in control of the future of college sports, then also this salary cap that cannot be met by only the largest schools. So, you know, on the competitive balance piece, over the past few days, as I've been talking to these conference commissioners, one of the ones I spoke with was the head of the WCC, Stu Jackson, who spent a lot of time in the NBA. And it would be a bit like having an NBA where the Eastern Conference had a higher salary cap than the Western Conference, and you wouldn't have competitive parity or fan interest if you're able to do that. And Commissioner Jackson had some very interesting ideas about how to solve this issue overall. You know, pointed out in the NBA they had Indiana and Oklahoma playing each other in the finals, and that was healthy for the sport. So, you know, one issue is competitive balance that this amendment seeks to address, but the other is holistically, what do we want college sports to be? If you vote for the SCORE Act, what you're saying is that football is more valuable and that the value in college sports comes from TV revenue share. That's because the underlying SCORE Act couldn't get around Title IX, so rather than directly address the Title IX issues, they said, well, we'll tie compensation to TV revenue. And each member tends to look at this issue sort of parochially at how does it affect their school, or they might look at it as fans. But if Congress is going to solve this issue, we should fundamentally look at what do we want college sports to be. And I would posit to you that college sports, in terms of its governance and the value that Congress places on it, should be a lot more like high school sports than it should be pro sports, where a cross-country runner is equally valuable as a football player. A volleyball player is equally as valuable as a basketball player, and so forth. And the NCAA is a feckless organization that does not have the power. And so Congress, rather than looking at this broken system, this flawed House settlement, has an opportunity right now to say fundamentally, what do we want college sports to be? How should it govern? And we have allies in this. Politics makes strange bedfellows. One of the members I've been working very closely on this issue with is Democratic Senator Maria Cantwell, who I actually ran against for U.S. Senate in 2012, but we talk now on a daily basis about this issue. I have also worked closely with a fellow named Cody Campbell, head regent at Texas Tech, has an organization called Save College Sports. He has a more expansive view how to solve this fundamentally. And I think the White House has some real interest in this issue as well. So the pieces are there to come together on this, but rather than look at how do we try to put some sideboards on this flawed settlement in the system, let's fundamentally, as Congress, decide what we want college sports to be. And the American public would do better if we treat all sports equally and say they have value, and then we treat the system holistically and not attribute the value in college sports. Congress should not put its thumbprint and say the value of college athletics is tied to how many people watch it on TV. That's a commercial engagement. We're looking to also look at overall public good on this issue. So a new organization that treats all athletes equally. And every sports fan, and I'm a big college football fan, we enjoyed college sports just as much in the 1980s, the 1990s, and the 2000s when college coaches were making lower salaries and there weren't 3 roller coasters and a pinball machine in the locker room. So you can get to the same societal benefit by treating everybody equally because you need competitive parity in that. So this amendment would get at that issue of what do we want college sports to be and how we treat athletes, and how do we have competitive parity in the system, and I would urge members to support.
I thank the gentleman. Does anyone else seek recognition on the amendment? I now recognize myself for 5 minutes in opposition. I appreciate the concerns of my colleague from Washington. However, the SCORE Act does not seek to dictate competitive parity. Instead, H.R. 4312 provides legal certainty and establishes a national framework for college sports. Market realities have always shaped college sports, with top conferences typically investing the most in their programs. Forcing equal distribution of revenue unfairly penalizes the conferences generating the revenue and risks driving those conferences away from the NCAA. I respectfully oppose this amendment and yield back. There's no further debate on the amendment. If not, the question is on the amendment by the gentleman from Washington. All in favor say aye.
Aye.
All opposed, no. No. In the opinion of the chair, the noes have it, and the amendment is not agreed to. A recorded roll call vote is ordered. Pursuant to the chair's previous announcement, this vote will be postponed. Are there any further amendments to the amendment in nature of substitute? For what purposes does the gentlelady from Pennsylvania seek recognition?
Mr. Chair, I have an amendment at the desk.
The clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to H.R. 4312, offered by Ms. Lee of Pennsylvania, identifier Lee_AMD_01.
Does the gentleman from Utah?
I reserve point of order.
Point of order is reserved. I now recognize the gentlelady from Pennsylvania for her 5 minutes.
Thank you, Mr. Chair. I'm offering an amendment to strike Section 9 from the bill to prevent the radical attempt to strip all student athletes of their right to ever be considered employees under the law. This provision of the bill is an extreme attempt to block student athletes from ever having the power to advocate for themselves and protect themselves from exploitation. At the same time, this bill provides the NCAA and wealthy, powerful athletic programs a blank check to coerce, control, and exploit college athletes without any risk of liability. Adding broad categorical exemptions from labor laws like this bill creates is virtually unprecedented. This move directly undermines the rights of every college athlete and our employment and labor laws. To determine whether someone is an employee under the Fair Labor Standards Act or the National Labor Relations Act, both laws have comprehensive, fact-specific tests that determine employee status on a case-by-case basis. These tests are flexible enough to adapt to the specific circumstances of each and every college athlete. Many college athletes already would not be considered employees under current law. So if the majority is so concerned about athletes being classified as employees, the solution is simple. Do not treat your college athletes like employees. In fact, this morning, Senator Chris Murphy and I reintroduced the College Athletes' Right to Organize Act to this effect. Our bill would clarify that college athletes are employees if and when their schools conditions any of a student athlete's scholarships or funding on their participation in college sports. Our bill also ensures that all public and private school students are entitled to the same rights and protections under the law. In fiscal year 24, the NCAA reported a record revenue of $1.38 billion, while too many D1 athletes still go hungry or they're forced to play while injured because getting cut from their athletic team means losing their food, their housing, their education. So I think we all can agree that it's far past time that student athletes have a seat at the table to hold the colleges that treat their student athletes like employees accountable. I urge my colleagues to support my bill, and to support this amendment, striking the employment section from this bill. Thank you, and I yield back.
I thank the gentlelady. To this gentleman from Utah, reserve his point of order. The reservation is withdrawn. Does anyone else seek recognition on the amendment? I now recognize myself for 5 minutes in opposition. The consequences of student athletes being treated as employees could be enormous for schools and students. Universities would face tough choices if they have to deal with the increased costs unionization and employee status cause. Many universities would shut down non-revenue generating athletic programs. Currently, we have more than 20,000 intercollegiate sports teams with more than 500,000 student athletes. Many of these teams and the opportunities they bring for student athletes could be on the chopping block. Reclassifying student athletes as employees would not only result in less opportunity for young people to continue their athletic careers, but it would also harm their education. Student athletes graduate at higher rates and earn higher grade point averages than students who do not play intercollegiate sports. Most student athletes do not want to punch a time card, pay taxes, let's state that again, pay taxes on income instead of receiving financial aid, or risk getting fired for poor on-field performance. There's never been a better time to be a student athlete. They can commercialize their name, their image, and likeness rights. Student athletes receive many other benefits. NCAA institutions provide student athletes with medical care for injuries incurred during intercollegiate athletics for at least 2 years after they leave school. Athletic scholarships cannot be reduced or revoked for any athletic reason during their reward period. And athletic scholarships can cover the full cost of attendance at an institution, including computers, tutoring, expenses for studying abroad, and paid internships after graduation. Given the significant progress made and ongoing reforms, now is not the time to upend collegiate athletics. I urge my colleagues to vote against this amendment and to vote yes on H.R. 4312. There's no further debate on the amendment. The question is on the amendment by the gentlelady from Pennsylvania. All in favor say aye. Aye. All opposed, no. No. In the opinion of the chair, the noes have it, and the amendment is not agreed to.
I request a recorded vote.
A recorded roll call vote is ordered pursuant to the chair's previous announcement. This vote will be postponed. Are there any further amendments to the amendment in the nature of a substitute to H.R. 4312? For what purposes does the gentleman from Washington seek to be recognized?
Thank you, Mr. Chair. I'd like to introduce my second amendment and speak to it. 021.
The clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to H.R. 4312, offered by Mr. Baumgartner of Washington, identifier BAUMGA_021.
I now recognize the gentleman from Washington for 5 minutes to support the amendment.
Thank you, Mr. Chair. This amendment deals with Title IX and whether Congress will decide to treat all athletes equally or whether Congress will try to pass a law that says that the value of athletics compensation should be based on TV revenue share. So again, in the flawed House settlement, as that was playing out, there's not a lot of money in college athletics. There's a lot of money in big-time football and basketball that goes into coaches' salaries and merry-go-rounds and locker rooms and these kind of things. But if Congress is going to weigh on this thing to deal with the Title IX issue, we should treat all athletes the same. That's what's in the public good, not tying it to TV revenue. And the fact that neither House nor this bill specifically address Title IX leaves open a huge can of worms to keep this issue in the courts making decisions rather than people's elected representatives. And fundamentally, sports is really important. Opportunities are important for everyone. There's more money in college athletics today than there were in the 70s, 80s, yet less opportunities to compete. And not only will not addressing the Title IX considerations put women's athletics at work, and I think this Congress should be so proud of what it's done so far working with this White House to protect women's athletics, but this bill would really be a step backwards direction because it won't be protected, but the competitive pressures of football will feed on themselves, and then it will put men's Olympic sports at risk as well, too. That's one of the reasons the USOC is so concerned. So the way around that is to treat all athletes equally, say that volleyball player and that wrestler and that lacrosse player, that cross-country runner, all those sports that America's sons and daughters play in high school and would like to compete at the highest level, that has equal value to that football player. And again, it won't cost football anything. All you need in football is competitive parity and balance, and you can essentially treat the system holistically. There's a pathway forward to do this. And so I think the conversation just gets so skewed on college athletics because if you just watch ESPN and watch the college football playoffs, you think that schools are awash in money in college athletics, but they are not. And the pressures of treating some athletes as to be better compensated based on TV revenue is just not in the public good, and the way around the Title IX issues to treat them equally. And if you do not specifically address Title IX in this bill, it will not resolve the underlying issues. Not only will the system exacerbate this slide towards a second NFL, but it'll continue to be in the courts. And so let's make a statement today by Congress saying all athletes are equal, all sports are equal, and I think that's much more in the spirit of the public good of how we should be looking at the future of college athletics. So let's say no to TV broadcasters and corporate interests determining the future of college athletics. Let's say yes to those young sons and daughters, those middle schoolers playing soccer right now, all of our kids looking at sports and saying all those sports are equal, like we do in high school, just like we do in high school. That's what we should be doing. This underlying amendment would urge support.
Gentleman yields back. Does anyone else seek recognition on the amendment? I recognize myself for 5 minutes. As a former cross-country runner and wrestler, I respect the intention of my colleague's amendment to ensure student athletes in sports outside of football and basketball receive compensation. However, this amendment undermines the core purpose of schools sharing revenue directly with student athletes, which is to reward the student athletes who drive athletic department revenue. Requiring equal pay across all sports ignores the reality that football and basketball generate the lion's share of revenue for athletic departments. Additionally, the goal of the SCORE Act is to create a sustainable framework, an emphasis on framework, not regulate college sports in every particular way. Right now, institutions have the flexibility to decide how to distribute this revenue, and that's the way it should stay. I respectfully oppose this amendment, and I yield back. There being no further debate on the amendment, the question is on the amendment by the gentleman from Washington. All in favor say aye. Aye. All opposed, no. No. In the opinion of the chair, the noes have it, and the amendment is not agreed to.
Mr. Chair, as for recorded vote.
A roll call vote is ordered. Pursuant to the chair's previous announcement, this vote will be postponed. Are there any further amendments to the amendment in the nature of a substitute to H.R. 4312? For what purpose does the gentleman from Texas seek to be recognized? For what? Let's walk back a bit. For what purpose does the gentlewoman from North Carolina seek to be recognized?
Thank you, Mr. Chairman. I have an amendment at the desk.
The clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to H.R. 4312, offered by Ms. Adams of North Carolina, identifier Adams_AMD_02.
For what purpose does the gentleman from Utah seek to be
Reserved, point of order.
Point of order is reserved. I now recognize the gentlelady from North Carolina for 5 minutes in support of her amendment.
Thank you, Mr. Chairman. In last week's markup of this bill in the Subcommittee on Commerce, Manufacturing, and Trade, there was a lot of discussion on the lack of Title IX protections in this bill. In fact, Chairman Guthrie committed to ensuring that this bill would not violate or supersede Title IX during the markup. But I'm glad to see that a section was added to the bill to prevent it from superseding Title IX protections, but that provision does not go far enough in protecting female athletes, and that's why I'm introducing this amendment. It's a common sense amendment, straightforward addition, and it would assure that no athletic conference discriminates against athletes on the basis of sex. The text of this amendment comes from Section 5B of my Fair Play for Women Act. I'd encourage any of my colleagues who support women's sports to take a look at that bill. We've all seen how sex-based discrimination impacts women's sports. Women's teams are shoved into substandard facilities for championships, provided with dated equipment, and under current bill text, they may be discriminated against in athletic association rules. This amendment ensures that athletic associations comply with anti-discrimination statutes, including that women are afforded the same amenities, facilities, goods, and benefits as men. If individual universities must comply with Title IX, it's only reasonable that college athletic associations have the same standards. passing this sweeping name, image, and likeness legislation without provisions explicitly protecting women could leave them open to blatant discrimination from athletic associations. I urge all of my colleagues to support this amendment, and I do yield back.
I thank the gentlelady. Does the gentleman from Utah
I
reserve?
withdraw my point of order.
Point of order is withdrawn. Does anyone else seek recognition on this amendment? I now recognize myself for 5 minutes to speak in opposition to the amendment. I appreciate my colleague's intention with this amendment. Discrimination on the basis of sex by the NCAA and conferences is a real issue. For example, the NCAA has discriminated in the past against female swimmers by forcing them to undress in front of male swimmers at NCAA-sanctioned championships. Addressing challenges like that one should have bipartisan support, and in fact, did have bipartisan support earlier this Congress when the House passed the Protection of Women and Girls in Sports Act. However, I have questions about how this amendment would work. For example, the language of the amendment appears to prohibit discrimination on the basis of sex by governing entities, but then includes a provision at the end of the amendment essentially exempting those entities from that requirement. I must oppose the amendment. I urge other members to oppose the amendment and support the underlying bill, and I yield back. There being no further debate
Mr.
on the
Chairman, I'll ask for a recorded vote.
we'll get
Okay.
to you shortly.
I'm sorry.
The question now is on the amendment by the gentlelady from North Carolina. All in favor say aye. Aye. All opposed, no. No. In the opinion of the chair, the noes have it, and the amendment is not agreed to. A roll call vote has been ordered.
Thank you, Mr. Chairman.
Pursuant to the chair's previous announcement, this vote will be postponed. Are there any further amendments to the amendment in the nature of a substitute? For what purpose does a gentleman from California seek to be recognized?
Mr. Chair, I have an amendment at the desk.
The clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to H.R. 4312, offered by Mr. Kiley of California, identifier Kiley_029.
I now recognize the gentleman from California for... A point of order is reserved. I now recognize the gentleman from California for 5 minutes in support of his amendment.
Thank you, Mr. Chair. I understand that there is a real need in many ways for this legislation, and I know that its purpose is to protect students, student athletes, institutions, and communities. But there are certain aspects of the bill that have the potential to do the opposite and have a long-term detrimental effect on universities, including one in my own district and others throughout the country. And specifically, I'm referring to Section 6, Clause 9, which provides absolute protection when it comes to dictating conference membership. This provision will impose a structural limitation that hinders the comprehensive growth and strategic advancement of colleges and institutions. These constraints affect economic development efforts through sports expansion in markets, as well as programmatic expansion and the ability for institutions to respond to the evolving economic needs of respective communities. Institutions should retain autonomy to chart their own strategic direction, particularly when considering membership or independent status within the Football Bowl subdivision. Membership growth and expansion is essential for fostering competitive excellence, financial growth and sustainability, and alignment with each institution's unique mission and long-term vision. And this proposed legislation, including that provision, that clause, puts restrictions on the independence of colleges and universities nationwide. And here's how this is played out in my own region. We have a university, our local university in Sacramento, known as Sac State, that is as prepared as any in the country to move from FCS to FBS. They've performed extremely well in FCS in recent years. They have the best recruiting class in the entire country. They've brought in a tremendous coach. They have tremendous buy-in from a vast alumni network in the region and throughout the state. By the way, on the basketball side of things, their new head coach is former NBA All-Star Mike Bibby, and Shaquille O'Neal has even signed on as the volunteer general general manager, causing the university to be rechristened Shack State in the eyes of many. Yet, despite all of this, they've run into roadblocks in moving up to FBS. Number one, they've been unable to get a conference invite, apparently because the NCAA has told conferences not to let in any more FBS schools. And then they said, all right, well, if you're not going to let us in a conference, at least let us be an FBS independent school. But the NCAA has denied that application. And so then if you, with this bill, if you add this additional absolute liability protection, then my concern is if a school like Shack State, which is as prepared as any in the entire country to make this leap, can't do so even under the current rules, and you add this additional barrier, then it's really going to be a situation where we're kicking the ladder down and denying this opportunity. And when you look at the fact that football accounts for 60% of all athletic revenue, this is really not small potatoes we're talking about here. And in the case of my region, this is something that's tremendously important to the school across many dimensions, but also to the entire Sacramento region, as this really can be an enormous driver of economic development. So there is a great deal of frustration in terms of how the rules are being applied right now, and that's why I've proposed this amendment to remove that particular provision. Mr. Chair, with that being said, I have tremendous trust in your leadership, and I know we've had very productive discussions on this, so I'm willing to withdraw the amendment today if the chair is willing to continue working with me on this topic. I'll yield to the chairman for a response.
Thank you, Mr. Kiley. I recognize from our discussions and your dedication to representing a district and concerns there that it's an important issue to you and the region you represent. Your amendment highlights valid concerns with how the process works with a school like Sacramento State or Shack State and how it wants to move up from FCS to FBS. While we've not been able to resolve this today, I hope that our discussions will continue as H.R. 4312 advances to the floor, and I yield back.
Thank you very much. Very much appreciate it and appreciate the opportunity to continue working on this. Given that commitment, I'll withdraw my amendment at this time, but I will have to vote against the bill when it comes to the floor if this issue isn't resolved in a way that satisfies these concerns. Thanks very much. I yield back.
I recognize that reality, and the gentleman's amendment is withdrawn, and I thank the gentleman for his collaboration. Are there any further amendments to the amendment in the nature of a substitute? I recognize the gentlelady from North Carolina.
Thank you, Mr. Chairman. I have an amendment at the desk, 528.
The clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to H.R. 4312, offered by Ms. Adams of North Carolina, identifier Adam NC _528.
I recognize the gentleman from Utah. Point of order is reserved. I now recognize the gentlelady from North Carolina for 5 minutes in support of her amendment.
Thank you, Mr. Chairman. This is yet another common sense amendment supporting women participating in college athletics. Currently, college athletic programs use a few reporting tricks to trick the federal government into believing that they are in full compliance with Title IX. When a female athlete competes in more than one sport, she is counted as more than one athlete on school rosters. It doesn't matter if I'm a runner and a basketball player, I am only one athlete, and college rosters should reflect that fact. Schools created an additional 2,252 roster spots thanks to this counting method in 2022. Schools also pad their rosters. According to a report by USA Today, 27 schools presented women's rowing team rosters with double the number of athletes allowed at most conference championships. Schools also, believe it or not, they count male practice players on women athletic rosters. Often, men's and women's basketball teams will practice together in scrimmages. These practice partners are by schools to the federal government as female athletes. 1 in every 4 women basketball players reported by schools to the federal government were actually men. My amendment stops these practices. It would strengthen reporting requirements to ensure that the Department of Education receives accurate information about athletic rosters. In addition, my amendment would also provide for more detailed, disaggregated data on how much money schools are providing to specific women's teams, women's coaches, and women's assistant coaches. As you all know, Title IX requires equitable distribution of funds between individual athletic teams. That provision is difficult to enforce without data. By making simple and common sense changes to reporting requirements, this amendment would ensure that Title IX is enforced as intended. So I urge my colleagues who support Title IX, who support women's sports, to support this amendment. And Mr. Chairman, I yield back.
I thank the gentlelady. Does the point of order is withdrawn. Are there any others who wish to speak on the amendment? I now recognize myself for 5 minutes in opposition to the amendment. While I agree with the sentiment and the goal of my colleague's amendment, I must oppose it in its current form. Increasing transparency in education, whether that's around costs, outcomes, or athletics, is something I believe we all support. However, that transparency must strike a balance between the information that students, families, and policymakers believe are the most relevant and the realities of actually collecting the data. This amendment would add substantial reporting requirements that in many ways seem impossible to track, including, for example, detailed and disaggregated information for club sports. The amendment also requires the Secretary to publish a gender equity report every 2 years using this new information, a pointless requirement that diverts attention from the department's real work to ensure, for example, that the FAFSA is on schedule, which would be amazing, and the student loan program is operational. Though I oppose this amendment, I want to emphasize that I commit to working with my colleague to improve the bill if there are places where more information and data collection is appropriate as this bill moves to the floor. Thank you, and I yield back. There being no further debate on the amendment, the question is on the amendment by the gentlelady from North Carolina. All in favor say aye. Aye. All opposed, no. No. In the opinion of the chair, the noes have it, and the amendment is not agreed to.
Mr. Chair, I ask for a recorded vote.
A roll call is ordered pursuant to chair's previous announcement. This vote will be postponed. Are there any further amendments to the amendment in the nature of a substitute to H.R. 4312? For what purpose does the gentleman from Washington seek to be recognized? Microphone.
Thank you, Mr. Chair. I would like to introduce my third amendment, 022.
The clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to H.R. 4312, offered by Mr. Baumgartner of Washington, identifier BAUMGA_022.
I now recognize the gentleman from Washington for 5 minutes in support of his amendment.
Thank you, Mr. Chair. This amendment deals with the absurdity of transcontinental regular season athletic competitions and transcontinental conferences, and the absurdity of sending volleyball players from California to New Jersey to compete on a school night. Reason I offer this amendment is, so why does this matter to the public? Well, again, college sports are highly subsidized public goods. Taxpayers put immense amount of money through Pell Grants and other subsidized student loans, and we should have a say that these funds are being used responsibly. I think as some members may know or may not know, Mike Leach was one of my best friends, and we talked frequently about college athletics. And then together, we taught a course called Insurgent Warfare in Football Strategy. And through that process, I got to know several athletic directors very well. At the time, the USC and UCLA made the shocking announcement that they were going to leave the Pac-12 and go to the Big Ten as a transcontinental conference. I got a phone call the next day from a previous Pac-12 athletic director and current Big Ten athletic director talking about the absurdity and how problematic that this would be. And then I got deeply invested in talking to elected officials up and down the West Coast about this. And they all said the same thing, that it was wrong, it was absurd, but they felt there was nothing they could do about it because of the TV dollars that were driving these decisions. So I don't think anyone in good faith can say that it makes any public purpose whatsoever that student athletes subsidized or funded by the taxpayers should be having their academic schooling interrupted by regular season transcontinental athletic competition. I'm not a global warming guy, but there's some global warming concerns there as well too, if you look at the debate of the West Coast schools going to the East Coast. But for those of you that is motivating, should think about that issue as well. So again, Congress should prohibit these things. Every actor, you talk up and down the college sports landscape, everyone thinks that it is crazy that West Coast schools are engaging in regular academic school year athletic competition on a regular basis, flying student athletes back and forth across the country. And Congress should be the adults in the room. These people are unable to do it, prohibit it themselves, even though they know it's all wrong and doesn't work. And this amendment would seek to say that we're not going to do that anymore, and I would urge its support.
The gentleman yields back. Are there any others who wish to speak on this amendment? I now then recognize myself for 5 minutes in opposition. I sincerely appreciate the gentleman from Washington's amendment to reduce student-athlete travel burdens. However, this amendment essentially forces conference realignment, which is not Congress's responsibility. Schools and conferences should address cross-country travel's impact on student-athlete welfare. H.R. 4312 cannot solve every problem in college athletics, and this travel ban is outside the scope of this bill. I respectfully oppose this amendment, and I yield back. There being no further debate on the amendment, the question is on the amendment by the gentleman from Washington. All in favor say aye. All opposed, no. No. In the opinion of the chair, the noes have it, and the amendment is not agreed to. A roll call vote is ordered pursuant to the chair's previous announcement. This vote will be postponed. Are there any further amendments to the amendment in the nature of a substitute to H.R. 4312? For what purpose does the gentleman from Texas seek to be recognized?
Mr. Chairman, I have an amendment at the desk, Amendment 02B.
The clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to H.R. 4312, offered by Mr. Kassar of Texas, identifier Kassar_AMD_02B.
I recognize the member.
Mr. Chairman, this bill contains some protections for student athletes, but in my view, those protections simply do not go far enough. But then shockingly, the bill also bans state legislators, be they Democratic or Republican state legislators, from pursuing higher standards for student athletes. So if we keep this section in the bill, in my view, the low standards for student athletes here cannot be expanded. A state legislature could not decide that schools and students in their state deserve higher pay or better health care coverage for athletes or expanded tuition assistance. So I would ask that the Republican majority on this committee consider striking the section in this bill that denies their own constituents potentially better protections if their state legislatures and their governors move forward with it. Student athletes and all college students should be able to get an education without needing to worry about how to pay for their next meal or afford the rent. And if state governments want to offer further protections beyond what's in this bill, I do not think that Congress should get in the way. So I urge passage of my amendment that would strike paragraph 1 in section 11 of the bill. Thank you, and I yield back.
The gentleman yields. Does anyone else seek recognition on this amendment? I now recognize myself for 5 minutes in opposition. Striking the Scores Act preemption provision eliminates the regulatory clarity needed to end the chaos of 33 conflicting state NIL laws. The SCORE Act's preemption clause ensures there is a uniform national framework for college sports that applies to every athlete, school, and conference across all 50 states. Conflicting state laws have fueled an NIL policy race with state legislatures, creating competitive advantages that are not only favorable to their own universities, but also directly undermine NCAA authority. Without preemption, every well-intentioned framework is derailed by conflicting state laws, creating legal uncertainty and competitive imbalances. This fractured system does no one in college sports any good, and so I strongly oppose the amendment, and I yield back. Being there is no further debate on the amendment, the question is on the amendment by the gentleman from Texas. All in favor say aye. Aye. All opposed, no. No. In the opinion of the chair, the noes have it, and the amendment is not agreed to.
Chairman, I request a recorded vote, please.
The no has it.
The no has it. There's only one no.
Unless you said the ayes have it, in which case, we'll take it.
The noes have it. We'll take that as. A roll call is ordered. Pursuant to the chair's previous announcement, this vote will be postponed. Are there any further amendments to the amendment in the nature of a substitute to H.R. 4312?
Mr. Chair, I have an amendment at the desk.
For what purpose does the gentleman from Washington seek to be recognized?
Thank you, Mr. Chair. This is my fourth and final amendment, Amendment 023.
The clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to H.R. 4312, offered by Mr. Baumgartner of Washington, identifier BAUMGA_023.
I now recognize the gentleman from Washington for 5 minutes in support of his amendment.
Thank you, Mr. Chair. This amendment, again, deals with the underlying absurdity of transcontinental athletic competitions during the academic school year for student athletes that are highly subsidized by the American taxpayer, and why the Congress, as representatives of the American taxpayer, have a direct and vested interest in this issue. If we can't ban the burden, we should at least support the students living under it. This amendment would put a fee, or a stipend, I should say, or stipend requirements that if a school is going to send a student athlete across more than 2 time zones for an athletic competition during the academic school year, and inevitably causing great distress to their academic studies, that they should get a stipend for doing that, and they should also be required to provide academic tuition support. And this amendment also looks at students have a greater role in say, of advisory committees as well, too. Again, there's a direct public interest here, and all these schools that felt forced in this stampede to chase ESPN and Fox Sports big-time football TV money and this rush of college football realignment in the last couple of years, all of them, almost all of them, not all, but almost all of them would like to find a way back out. They can't do it themselves. This amendment would really provide some needed safeguards for student athletes, first and foremost, and then may provide the incentive for them to make a decision that's in the better interest of their student athletes. You know, there is a lot that has gone wrong with college athletics in the last 4 years. One of them really being the slide toward professionalization across all things. But let's give these student athletes at least a chance to complete their academic work in good standing and at least provide some safeguards if they are going to get sent on a school night across the country, that they get some support and some stipend for that. And so I'd urge everyone to support the amendment.
The gentleman yields back. Does anyone else seek recognition on this amendment? I now recognize myself for 5 minutes in opposition. I respect and support the gentleman from Washington's intent to give student athletes an avenue to provide input on policies that impact them. However, NCAA rules already require all Division I institutions to have student-athlete advisory committees, ensuring athletes have a say. In addition, the ANS offered by Representative McLean includes new language requiring conferences and governing bodies like the NCAA to include student representatives in decision-making. We recognize the importance of a student voice, which is why the ANS addresses this issue. That said, I would like to work with the gentleman on this topic as this bill moves to the floor. Additionally, I support my colleagues' concern with student athletes traveling across multiple time zones for sporting events. Unfortunately, this is a regular procedure for many schools, and imposing a requirement that they must provide a $1,000 stipend to each student athlete is overly prescriptive and would likely cause more harm than good. I respectfully oppose this amendment, and I yield back. Being no further debate on the amendment, the question is on the amendment by the gentleman from Washington. All in favor say aye. Aye. All opposed, no. No. In the opinion of the chairs, the noes have it, and the amendment is not agreed to. A roll call vote is ordered pursuant to the chair's previous announcement. This vote will be postponed. Are there any further amendments to the amendment and the nature of the substitute to H.R. 4312? For what purpose does the gentlelady from Arizona seek to be recognized?
Mr. Chair, I have an amendment at the desk.
The clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to H.R. 4312, offered by Ms. Ansari of Arizona, identifier Ansari_AMD_01.
For what purpose does the gentleman from Utah seek to be
I
recognized?
reserve point of order.
A point of order is reserved. I now recognize the gentlelady from Arizona for 5 minutes in support of her amendment.
Thank you. Nowhere in this bill does it make any mention of Title IX or set requirements when it comes to sex discrimination, which has been documented in the sports world time and time again. This amendment is about protecting student athletes from abuse, harassment, and discrimination. It's about ensuring that every staff member who works with athletes knows the rights these students are entitled to and knows what to do if those rights are being violated. Republicans keep talking about wanting to protect women and girls in sports. If that's true, then they should vote for this amendment. They probably won't, because here's the truth. Republicans in Congress have shown again and again that they are willing to look the other way when it comes to sex abuse in sports. They did it when Jim Jordan, now one of the most powerful Republicans in Congress, refused to take action as student athletes at Ohio State were being abused by a team doctor. Multiple former wrestlers have testified that Jordan knew, that he was told, that he did nothing. Not only did he do nothing, but since then he's worked to discredit survivors and rewrite history to avoid accountability. And yet, now he's the chair of the very powerful Judiciary Committee. Or look at Linda McMahon, who ran the WWE and is now Trump's education secretary. For years, under her leadership, WWE was a hotbed of sexual misconduct and toxic workplace culture. And it wasn't until public pressure mounted that real scrutiny even began. Again, a pattern of looking away, of shielding abusers, and prioritizing power over people. And it's not just in sports. They've ignored and downplayed allegations against President Trump himself for years. This is a party whose leader has been found liable in a court of law for sexual abuse. This tolerance of sexual discrimination and abuse is a systemic failure, and one that too many Republicans in power have enabled. Most of them will probably vote against this amendment that would make it more likely for abuse to be reported when it happens. This amendment simply says, if you work with college athletes, you should know what Title IX is. You should know how to report discrimination. And if you suspect abuse, you don't bury it. You don't sit on it. You don't cover it up. You report it. To my Republican colleagues, if you vote against this amendment, you're choosing to side with silence. You're choosing to uphold a system that lets abuse fester. You're saying yet again that protecting students comes second to protecting institutions. I, for one, am proud to stand on the side of survivors, of student athletes, and of basic decency. I urge my colleagues to vote yes, and I yield back.
I thank the gentlelady. Now I recognize the gentleman from Georgia, Mr. Allen, for 5 minutes.
Strike the last word.
Gentleman is recognized.
I would like to bring up 2 points of order that have come up. We're marking up this as well in the Energy and Commerce Committee today, and 2 amendments that are going to be part of that markup in Energy and Commerce. First is under Military Service Academy and NIL remarks. The August Pfluger is going to propose an amendment to support legislation and support this legislation. Appreciate the hard work this committee, the Energy and Commerce Committee and Judiciary Committee have done to work together to this tri-committee process on the SCORE Act. However, I'd like to echo the concerns of a colleague of mine that were brought up, August Pfluger, that were brought up in the Energy and Commerce Committee regarding Military Service Academy athletes' name, image, and likeness. When it comes to the U.S. Air Force Academy, NIL and the transfer portal have cost the Academy and taxpayers over $28 million. Over 111 total cadet athletes have transferred out of the Academy, and considering the cost of education at the Academy is valued at over $165,000, this has significant financial implications on the taxpayer. Given that service is integral to the mindset of military service academies, NIL is incompatible with their mission and commitment to service. For every cadet athlete who transfers out of a service academy, a spot has been taken away from a cadet who wishes to serve their country as a commissioned officer. I hope that the Education and Workforce Committee will work with ENC and Congressman Pfluger to address this critical issue. Thank you. And then I have another amendment. This amendment basically codifies the old NCAA 5 years of eligibility rules for NIL. I hope that the committee will work with Representative Palmer on this important issue. And basically what it does, it says that a student athlete may enter into a name, image, and likeness agreement. It makes academic progress towards graduating with an undergraduate degree from the institution and graduates within 5 years after the date of enrollment in that institution. And in the case of a transfer from another institution at the end of an academic year, the student athlete has sufficient credits to qualify for the next academic year. And those 2 amendments will be proposed during the amendment process as this bill moves to the floor. And I would appreciate the education and workforce support of these 2 amendments. And with that, I yield back.
I thank the gentleman. Are there any others who seek to speak on this amendment? I now recognize myself for 5 minutes to speak in opposition to the amendment. I appreciate my colleague on the other side of the aisle's intention to ensure student athletes know their rights under Title IX. However, the NCAA already mandates annual Title IX training for student athletes and athletic department employees, making the amendment's training requirements duplicative. Furthermore, nothing in the SCORE Act diminishes Title IX enforcement, as Section 7 explicitly preserves its protections, ensuring no conflict with existing federal law. Existing Title IX compliance mechanisms, including institutional policies and oversight by the Department of Education's Office for Civil Rights, are robust and sufficient to address sex discrimination in athletics, rendering the amendment's requirements redundant. That said, we are all interested in ensuring that institutions and their students and employees understand their Title IX obligations and rights. Additionally, Democrats' expression of concern for female student athletes rings hollow. Earlier this Congress, the House of Representatives approved H.R. 28, the Protection of Women and Girls in Sports Act. This bill guarantees women's access to a fair playing field, ends discrimination against women, and restores safety and privacy to female student athletes. Only 2 Democrats voted for that bill, neither of whom are on this committee. I urge my colleagues to ignore the hypocritical claims from my Democrat colleagues that they are concerned about protecting and expanding women's sports, and I urge opposition to this amendment. Being that there is no further debate on the amendment, the question is on the amendment by the gentlelady from Arizona. All in favor say aye. Aye. All opposed, no. No. In the opinion of the chair, the noes have it, and the amendment is not agreed to.
Mr. Chairman, recorded vote, please.
A roll call vote is ordered. Pursuant to the chair's previous announcement, this vote will be postponed. Are there any further amendments to the amendment in the nature of a substitute to H.R. 4312? For what purpose does the gentleman from Virginia, the ranking member, seek to be recognized?
I have an amendment at the desk, Scott, AMD 03.
The clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to H.R. 4312, offered by Mr. Scott of Virginia, identifier Scott_AMD_03.
Does the gentleman from Utah reserve a point of order?
Reserve point of order.
Point of order is reserved. I now recognize the gentleman from Virginia, the ranking member, for 5 minutes in support of the amendment.
Thank you, Mr. Chairman. This is a simple amendment. It just, for whatever rights the students have left, it just makes sure that they have right to vindicate those, they have an opportunity to vindicate those rights. If they don't get their three-year health benefits, or if they don't have access to the NIL benefits, they ought to be able to vindicate those rights. It says you have a private right of action. Under Title VI, there's no private right of action, so we want to make sure they don't get caught up in something like this. This specifically says they have a private right of action to enforce the rights that are left after this bill passes.
Does the gentleman reserve the point of order? Point of order is not reserved. Does anyone else seek recognition on this amendment? I now recognize myself for 5 minutes in opposition. I thank the ranking member for his amendment, but I must oppose it. We have added additional enforcement language to the bill in the ANS. For example, under the ANS, institutions will have to comply with the requirement outlined in Section 5 of the bill as a condition on participating in federal student aid programs under Title IV of the Higher Education Act. Additionally, the ANS gives state attorneys general the power to enforce the bill's protections of student athletes' NIL rights under Section 3. Because of these additional enforcement measures added to the bill through the ANS, I do not believe that a private right of action is necessary. I urge my colleagues to oppose the amendment and support the underlying bill, and I yield back. Being no further debate on the amendment, the question is on the amendment by the gentleman from Virginia. All in favor, say aye.
Aye.
All opposed, no. No. In the opinion of the chair, the noes have it, and the amendment is not agreed to. A recorded vote is ordered. Pursuant to the chair's previous announcement, this vote will be postponed. Are there any further amendments to the amendment in the nature of a substitute to H.R. 4312? For what purposes, gentlemen from Virginia seek to be recognized?
Mr. Chairman, I ask unanimous consent to enter into the record letters from the American Economic Liberties Project, CLASP, American Association for Justice, the AFL-CIO Sports Council, the National College Players Association, the Women's Sports Foundation, and the Democratic Women's Caucus, all in opposition to H.R. 4312.
Without objection, they will be entered. Are there any further amendments to the amendment in the nature of a substitute to H.R. 4312? Let me notify the committee that we will suspend for a few minutes and then return. Pursuant to the previous order, the chair declares the committee in recess subject to the call of the chair. We expect to reconvene at 2:30 p.m. For votes. So the committee stands in recess. public service announcement. While we're all waiting for others to arrive here, you might Committee will reconvene and come to order following our recess. We will proceed to postpone requests for recorded votes. We will now be voting on 4 amendments to the amendment in the nature of a substitute to H.R. 1319.
Mr. Chairman. Mr. Chairman, I move to strike the last word pursuant to House Rule 11, Clause 2H4B, which states that upon returning to postpone questions, the underlying proposition remains subject to further debate or amendment to the same extent as when the question was postponed, and therefore I move to strike the last word and speak.
You're recognized.
Thank you, Mr. Chairman. Mr. Chairman and colleagues, the committee markup today noticed that we would consider House Resolution 4307, the Enhancing Detection of Human Trafficking Act, which is bipartisan legislation on assisting criminal law enforcement through the Department of Labor in detecting human trafficking, but it has been abruptly moved from consideration. Mr. Chairman and colleagues, the public deserves to know the reason why the bill was pulled. Is it because the majority did not want to vote on my amendment requiring the Department of Labor to release the Epstein files? The American people deserve to learn the circumstances and full scope of the crimes Mr. Epstein committed, and it's definitely relevant to this bill because it's through the Department of Labor that this work on human trafficking is happening. That's what this bill is about, and if you may recall, Mr. Chairman and colleagues, Donald Trump's first labor secretary was Alex Acosta, who was the prosecutor who entered into a sweet deal with Jeffrey Epstein and then later had to resign once there was an investigation into that plea deal. I hope it's not because the Republican majority wants to cover up for a sex offender. I don't think that's what these members of this committee believe in. This is about transparency, Mr. Chairman and colleagues. Last week, Speaker Johnson said the House Republicans are for transparency. Yet, my colleagues, are you willing to go to great lengths to keep this information in the shadows? I'm concerned, Mr. Chairman, because the public deserves transparency. We know that there were problems through the first labor secretary, and we know that once that deal came to light through an investigation by the Justice Department's Office of Professional Responsibility, it received bipartisan condemnation, including from a former Republican Senator Sass, who said letting a well-connected billionaire get away with child rape and international sex trafficking isn't poor judgment, it is a disgusting failure. Americans ought to be enraged. And then Secretary Acosta resigned. Now, Mr. Chairman, this is an opportunity for us as a committee, when we're working on addressing child trafficking and human trafficking, to say we want transparency. Even former Secretary Acosta said that the Epstein affair was vastly more lurid and sweeping than when he was first involved. So, Mr. Chairman and committee members, I've been in this committee for more than a dozen years. I've had the opportunity to spend time with you and get to know many of you on the other side of the aisle, and we might not always agree on policies, but I can't imagine that any of you in this committee would want to cover up for a sex offender or make excuses for anyone who participated in sex trafficking. I certainly hope that you agree and do the right thing for America and for your constituents. If you support transparency, this should have been an easy yes vote. I'm disappointed that we are not able to consider this amendment today. I hope we can at a future time. It's really about the transparency the American people deserve. And I yield back.
Generally yields. This gavel and the committee's agenda authority rests solely with the chair. Therefore, the chair has discretion whether or not to consider measures at committee markups. We'll therefore continue with our next item, consideration of postponed requests for recorded votes. The amendment offered by Representative Ansari, AMD /03. A recorded vote is requested. Members will record their
Point of
votes
order, Mr. Chairman.
using the electronic voting
Point of order,
system.
Mr. Chairman. Mr. Chairman, could you,
Mr. Chairman?
could you give the brief description of what we're voting on?
I move the previous question on the.
Wait. Brief description, what we're.
Just read the description of what we're voting on.
It's Representative Ansari's AMD /03 excludes flexible work arrangements from consideration in determining whether an individual is an employee or of another person.
Thank you.
A recorded vote is requested. Members will record their votes using the electronic voting system. The chairman intends to vote no.
Ranking member intends to vote yes.
The clerk will open the vote. Have all members been recorded who wish to be recorded? Do any members wish to change their vote? Hearing none, will the clerk please close the vote and announce the tally?
Mr. Chairman, on this vote, there are 16 yeas and 19 nays.
The amendment is not adopted. The question now occurs on the amendment in the nature of a substitute as amended to H.R. 1319. All in favor say aye.
No, sorry. The next amendment, we're doing Miss Lee's.
Oh.
Miss Lee's.
Okay. The next amendment, I guess we have the 4 amendments here. The next amendment is Representative Lee's amendment, AMD_04, requires a court rather than an arbitrator, regardless of any contractual provision, to determine whether an individual is an independent contractor rather than an employee. Recorder vote is requested. Members will record their votes using electronic voting system. The chairman intends to vote no.
Ranking member intends to vote yes.
The clerk will open the board. Have all members been recorded who wish to be recorded? Do any members wish to change their vote? Hearing none, will the clerk please close the vote and announce the tally?
Mr. Chairman, on this vote, there are 16 yeas and 19 nays.
The amendment is not adopted. The next amendment is the Omar Amendment, AMD_02. The chairman intends to vote no.
Could you describe the bill we're voting on?
You don't have them written down for you.
Clarifies the details of the way the work is performed does not include the exercise by worker of discretion that is ordinary and customary. I intend to vote yes.
That's correct. The chairman intends to vote no. The clerk will open the vote. Have all members been recorded or wish to be recorded? Do any members wish to change their vote? Hearing none, will the clerk please close the vote and announce the tally?
Mr. Chairman, on this vote, there are 16 yeas and 19 nays.
The amendment is not adopted. We now move to Representative Bonamici's amendment prohibiting application of the bill in cases related to unlawful child labor under the Fair Labor Standards Act, AMD_01. The chairman intends to vote no.
Ranking member intends to vote yes.
The clerk will open the vote. Have all members been recorded who wish to be recorded? Do any members wish to change their vote? Hearing none, will the clerk please close the vote and announce the tally?
Mr. Chairman, on this vote, there are 16 yeas and 19 nays.
The amendment is not adopted. The question now occurs on the amendment in the nature of a substitute as amended to H.R. 1319. All in favor say aye. Aye. All opposed, no.
No.
In the opinion of the chair, the ayes have it, and the amendment in the nature of a substitute as amended is agreed to. I hereby move that the committee report the bill H.R. 1319 to the House of Representatives with amendment and with recommendation that the amendment be agreed to and the bill do pass. The question now occurs on the chair's motion. All in favor say aye. Aye. All opposed, no.
No.
In the opinion of the chair, the ayes have it, and the motion is agreed to.
Recorded vote.
Recorded vote is requested. Members will record their votes using the electronic voting system. The chairman intends to vote aye.
Ranking member intends to vote no.
Please open the vote. Have all members been recorded who wish to be recorded? Do any members wish to change their vote? Hearing none, will the clerk please close the vote and announce the tally?
Mr. Chairman, on this vote, there are 19 yeas and 16 nays.
The ayes have it, and the motion is agreed to. H.R. 1319 as amended, and the accompanying material shall be transmitted to the House of Representatives. The chair notes for the record that a quorum is present. I hereby move that the committee report the bill H.R. 1320 to the House of Representatives with amendment and with the recommendation.
Point of order, Mr. Chairman. Don't you have to go through some stuff to?
We've already voted the 1320. There were no amendments.
Don't you have to?
Remember that we took the, I don't remember that we took the, did we take the?
Don't you have,
We did vote yes.
you voted yes.
On the ANS.
Don't you have to go through some?
No, we voted
No,
yes.
if we already voted on the ANS, we don't.
Yeah, but then members have requisite number of members.
He'll have to say that after we do the vote on the motion to report the requisite number of days.
Yeah, we just passed the bill.
Oh, yes, the requisite number of days on the previous bill.
I hereby move that the committee report the bill H.R. 1320 to the House of Representatives with amendment and with recommendation that the amendment be agreed to and the bill do pass. The question now occurs on the chair's motion. All in favor say aye. Aye. All opposed, no.
No.
In the opinion of the chair, the ayes have it, and the motion is agreed to.
Recorded vote.
Recorded vote is requested. Members will record their votes using the electronic voting system. The chairman intends to vote aye.
Ranking member intends to vote no.
Have all members been recorded who wish to be recorded? Do any members wish to change their vote? Hearing none, will the clerk please close the vote and announce the tally?
Mr. Chairman, on this vote, there are 19 yeas and 16 nays.
The ayes have it, and the motion is agreed to. H.R. 1320 as amended, and the accompanying materials shall be transmitted to the House of Representatives. The chair notes for the record that the quorum is present. We'll now be voting on one amendment to the amendment in the nature of a substitute to H.R. 4366. The amendment offered by Representative Adams, NC /529 prevents the provision amending the definition of employer under the Fair Labor Standards Act from coming into effect in cases of unlawful child labor under the FLSA. A recorded vote is requested. Members will record their votes using electronic voting system. The chairman intends to vote no.
Ranking member intends to vote yes.
Please open the vote. Have all the members been recorded who wish to be recorded? Do any members wish to change their vote? Hearing none, will the clerk please close the vote and announce the tally?
Mr. Chairman, on this vote, there are 16 yeas and 20 nays.
The amendment is not adopted. The question now occurs on the amendment in the nature of a substitute as amended to H.R. 4366. All in favor say aye. Aye. All opposed, no.
No.
In the opinion of the chair, the ayes have it, and the amendment in the nature of a substitute is agreed to. I hereby move that the committee report the bill H.R. 4366 to the House of Representatives with amendment and with recommendation that the amendment be agreed to and the bill do pass. The question now occurs on the chair's motion. All in favor say aye. Aye. All opposed, no.
No.
In the opinion of the chair, the ayes have it, and the motion is agreed to.
Recorded vote.
Recorded vote is requested. Members will record their votes using an electronic voting system. The chairman intends to vote aye.
Ranking member intends to vote no.
Open the vote, please. Have all members been recorded who wish to be recorded? Do any members wish to change their vote? Hearing none, will the clerk please close the vote and announce the tally?
Mr. Chairman, on this vote, there are 20 yeas and 16 nays.
Mr. Chairman, I have an amendment at the desk. Pursuant to House Rule 11.
Mr. Chairman.
2H4B.
Chairman, I move the previous question on the amendment in the nature of a substitute and all amendments thereto.
Mr. Chairman, I have an amendment at the
Question
desk.
is on ordering the previous
HR
question.
4312.
All those in favor say aye.
Parliamentary.
Aye. All those opposed say no. No. In the opinion of the chair, the ayes have it, and the previous question is ordered on the amendment in the nature of a substitute. Previous question having been ordered on the amendment in the nature of a substitute. I hereby move that the committee report the bill H.R. 4366 to the House of Representatives with amendment and with the recommendation that the amendment be agreed to and the bill do pass. The question now occurs on the chair's motion. All in favor say aye. Aye. All opposed, no. In the opinion of the chair, the ayes have it, and the motion is agreed to.
What,
4366.
was that the,
You want to record a vote?
what was the motion? Parliamentary inquiry, Mr. Chairman.
I think it was here.
What was the motion?
Okay, you know better.
To report 4366.
Did we-
Recorded.
Now he's reporting.
Did we have a vote, did we have a vote on the amendment in nature of a substitute?
We did, yes.
Okay, recorded vote then.
Recorded votes has been requested. Members will record their votes using the electronic voting system. The chairman intends to vote aye.
Ranking member intends to vote no.
Please open the vote. Have all members been recorded who wish to be recorded? Do any members wish to change their vote? Hearing none, will the clerk please close the vote and announce the tally?
Mr. Chairman, on this vote, there are 20 yeas and 16 nays.
The ayes have it, and the motion is agreed to. H.R. 4366 as amended, and the accompanying materials shall be transmitted to the House of Representatives. The chair notes for the record that a quorum is present.
Mr. Chairman, I have an amendment at the desk to H.R. 4312, the next bill to be considered.
Mr. Chairman, I move the previous question on the amendment in the nature of substitute and all amendments thereto.
The question is on ordering the previous question. All those in favor say aye. Aye. All those opposed, no. In the opinion of the chair, the ayes have it, and the previous question is ordered on the amendment in the nature of a substitute. Roll call vote is requested. The chairman intends to vote no on the roll call. The chairman intends to vote yes.
That's agreeable. I'll vote no too.
Chairman intends to vote aye.
Intend to vote no.
The clerk will open the board.
She's creating the vote, so just
Parliamentary inquiry, what are we voting on, sir?
voting on the motion to move the previous question.
We're voting on the motion to move the previous question.
Which will end.
For which bill?
It's 4312.
4312. to do this, everyone. The clerk is creating the votes for the board. Is it ready? The chairman intends to vote yes.
Ranking member intends to vote no on the previous question.
The clerk will open the vote on the previous question. Have all members been recorded who wish to be recorded? Do any members wish to change their vote? Hearing none, will the clerk please close the vote and announce the tally on the previous question?
Mr. Chairman, on this vote, there are 20 yeas and 16 nays.
Now we move to the
Proceed. Proceeds a Courtney vote. Courtney, 24. Amendment offered by Mr. Courtney.
We'll now proceed to the amendment offered by Mr. Courtney, titled COURTN_024, extends medical coverage for student athletes from 3 years to 10 years. The amendment, the recorded vote is requested. Members will record their votes using the electronic voting system. The chairman intends to vote no.
Ranking member intends to vote yes.
The clerk will open the vote. Have all members been recorded or wish to be recorded? Do any members wish to change their vote? Hearing none, will the clerk please close the vote and announce the tally?
Mr. Chairman, on this vote, there are 16 yeas and 20 nays.
The amendment is not adopted. We now move to Representative Baumgartner, Baumga, /020 is titled, requires the council established in the Section 6 to develop policies on revenue sharing between institutions and compensation limits. A recorded vote is requested. Members will record their votes using an electronic voting system. The chairman intends to vote no.
Ranking member intends to vote yes.
Please open the vote. Have all members been recorded who wish to be recorded? Do any members wish to change their vote? Hearing none, will the clerk please close the vote and announce the tally?
Mr. Chairman, on this vote, there are 16 yeas and 19 nays.
The amendment is not adopted. We now move to Representative Lee's amendment, Lee_AMD_01, strikes the prohibition on student athletes becoming employees. A recorded vote is requested. Members will record their votes using an electronic voting system. The chairman intends to vote no.
Ranking member intends to vote yes.
Please open the vote. Have all members been recorded who wish to be recorded? Do any members wish to change their vote? Hearing none, will the clerk please close the vote and announce the tally?
Mr. Chairman, on this vote, there are 15 yeas and 20 nays.
The amendment is not adopted. We now move to Representative Baumgartner's amendment. Baumga_021 requires any institution that provides compensation to student athletes to distribute compensation in equal amounts to all student athletes. A recorded vote is requested. Members will record their votes using an electronic voting system. The chairman intends to vote no.
Ranking member intends to vote yes.
Please open the vote. Have all members been recorded who wish to be recorded? Do any members wish to change their vote? Hearing none, will the clerk please close the vote and announce the tally?
Mr. Chairman, on this vote, there are 14 yeas and 21 nays.
The amendment is not adopted. We now move to the amendment by Representative Adams, Adams_AMD_02, inserts broad non-discrimination language regarding discrimination on the basis of sex into the bill. A recorded vote is requested. Members will record their votes using an electronic voting system. The chairman intends to vote no.
Parliamentary inquiry, Mr. Chairman, could you read the description again?
Inserts broad non-discrimination language regarding discrimination on the basis of sex into the bill.
What's the next one?
Adams_AMD_02.
Prohibits discrimination on the basis of sex by interstate and intercollegiate athletic associations.
I'm reading it as I see it.
We'll pull up the text. We'll pull up the text to make sure.
We're clarifying. They're looking at it.
But we couldn't hear you when you said that.
They're checking. We'll read it again. Description. And then we'll see. His mic wasn't on.
I think that's.
Prohibits discrimination on the basis of sex.
Absolutely, I appreciate it. Go ahead.
What do you want to read?
Can you have a copy?
Mr. Chairman, is this the amendment that prohibits discrimination on the basis of sex by interstate intercollegiate athletic associations?
That is correct.
Thank you.
A recorded vote is requested. Members will record their votes using the electronic voting system. The chairman intends to vote no.
Ranking member intends to vote yes.
Please open the vote. Have all members been recorded who wish to be recorded? Do any members wish to change their vote? Hearing none, will the clerk please close the vote and announce the tally?
Mr. Chairman, on this vote, there are 16 yeas and 19 nays.
The amendment is not adopted. We now move to Representative Adams, Adam NC_528, significantly expands the reporting on athletics required in the Higher Education Act to include reporting on intramural and club-level team sports. Also creates significant new reporting for colleges regarding a number of factors as it relates to college sports. A recorded vote is requested. Members will record their votes using the electronic voting system. The chairman intends to vote no.
Ranking member intends to vote yes.
Please open the vote. Have all members been recorded who wish to be recorded? Do any members wish to change their vote? Hearing none, will the clerk please close the vote and announce the tally?
Mr. Chairman, on this vote, there are 16 yeas and 19 nays.
The amendment is not adopted. We now move to Representative Baumgartner's amendment, BAUMGA_022, prohibits a conference from scheduling a regular season intercollegiate athletics competition in a location that is more than 2 time zones away from the primary campus of the school.
Mr. Chair, I'd like to withdraw the amendment.
Representative Baumgartner, you request?
Which one is the request for vote?
Voice vote.
We'll just say.
Representative Baumgartner requests to withdraw this amendment. Without objection,
Okay, proceed.
should we do a voice vote?
No, it's fine. We're fine. We've already done the voice vote. We're good. We're good.
The amendment was withdrawn. We'll proceed to the Kassar amendment. Kassar /AMD 02B specifically strikes the preemption language as it relates to compensation, payment, benefits, and employment status of student athletes. A recorded vote is requested. Members will record their votes using the electronic voting system. The chairman intends to vote no.
Ranking member intends to vote yes.
Please open the vote. Have all members been recorded who wish to be recorded? Do any members wish to change their vote? Hearing none, will the clerk please close the vote and announce the tally?
Mr. Chairman, on this vote, there are 15 yeas and 20 nays.
The amendment is not adopted. We now move to Representative Baumgartner's amendment to BAUMGA /23, requires institutions generating at least $20 million in athletic revenue to establish a student-athlete advisory committee to provide guidance on institutional policies affecting the well-being of student-athletes, requires these schools to also provide certain benefits to student-athletes that are required to travel across more than 2 time zones. A recorded vote is requested. Members will record their votes using the electronic voting system. The chairman intends to vote no.
Ranking member intends to vote yes.
Please open the vote. Have all members been recorded or wish to be recorded?
No.
Do any members wish to change their vote? Hearing none, will the clerk please close the vote and announce the tally?
Mr. Chairman, on this vote, there are 16 yeas and 19 nays.
The amendment is not adopted. We now move to Representative Baumgartner's, excuse me, we move to Representative Ansari's amendment, Ansari /AMD /01, requires colleges to provide to any employee associated with athletics an annual training on Title IX, what conduct constitutes sex discrimination, and the procedure for submitting Title IX complaints. Also requires that these employees notify the Title IX coordinator when the employee has received information about sex discrimination. A recorded vote is requested. Members will record their votes using the electronic voting system. The chairman intends to vote no.
Ranking member intends to vote yes.
Please open the vote. Have all members been recorded who wish to be recorded? Do any members wish to change their vote? Hearing none, will the clerk please close the vote and announce the tally?
Mr. Chairman, on this vote, there are 16 yeas and 20 nays.
The amendment is not adopted. We now move to Representative Scott's amendment, Scott /AMD /03, inserts a private right of action for both current or previous student athletes to bring an action in federal or state court against the intercollegiate athletic association or institution alleging a violation of the act. A recorded vote is requested. Members will record their votes using the electronic voting system. The chairman intends to vote no.
Ranking member intends to vote yes.
Please open the vote. Have all members been recorded who wish to be recorded? No. Do any members wish to change their vote? Hearing none, will the clerk please close the vote and announce the tally?
Mr. Chairman, on this vote, there are 16 yeas and 20 nays.
The amendment is not adopted. The question now occurs on the amendment in the nature of a substitute as amended to H.R. 4312. All in favor say aye. 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 All opposed, no. In the opinion of the chair, the ayes have it, and the amendment in the nature of a substitute as amended is agreed to.
Recorded vote.
Recorded.
Wait a minute. Not the ANS.
Want to record vote on ANS?
Not the ANS. Not the ANS.
I hereby move that the committee report the bill H.R. 4312 to the House of Representatives with amendment and with the recommendation that the amendment be agreed to and the bill do pass. The question now occurs on the chair's motion. All in favor say aye. Aye. All opposed, no. In the opinion of the chair, the ayes have it and the motion is agreed to.
Recorded vote.
Recorder vote is requested. Members will record their votes using the electronic voting system. The chairman intends to vote aye.
Ranking member intends to vote no.
Please open the vote. Have all members been recorded who wish to be recorded? Do any members wish to change their vote? Hearing none, will the clerk please close the vote and announce the tally?
Mr. Chairman, on this vote, there are 18 yeas and 17 nays.
The ayes have it, and the motion is agreed to. H.R. 4312 as amended, and the accompanying material shall be transmitted to the House of Representatives. The chair notes for the record that a quorum is present. I ask unanimous consent that staff be authorized to make necessary technical and conforming changes to today's bills without objection so ordered. Pursuant to House Rule 11, Clause 2L, I give notice that all members have the requisite number of days to file supplement, minority, additional, or dissenting views without objection so ordered. Without objection, any member who wishes to insert materials in the record may do so by submitting them to the committee clerk electronically by the end of the day today. If there is no further business before the committee.
Mr. Chairman, I notify the committee that I intend to submit dissenting views.
Pardon?
I intend to submit dissenting views. It's not that important.
That's fine. Without objection, the committee stands adjourned.